Step right up, step right into another amazing show. And trust me, you will adore today's show. Yes, you. Auntie Miracle B is live on YouTube right now. B.
Lil' P on the track, boy.
What's the business? Phone jumping off the chain like what's the business?
40 years old, trying to rap like what's the business?
I'ma pull up with the yay like what's the business?
Counting cash in my mom's kitchen, what's the business?
Eating lunch with the blood like what's the business?
Too many baby mamas, that's the business.
Hey, y'all double jump like what's the business? 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 What's the business?
Mowing down Christmas parades like that's the business.
What's the business? 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 Catch me sliding to the trap like what's the business?
Had to call mom for a lift like what's the business?
Grinding trying to make a stack like what's the business?
Watch some SVU and now no law, that's the business.
I'ma pull up on you like what's the business?
Disrespectful to everybody, that's the business.
She gon' give it to the kid like what's the business?
Subject matter jurisdiction, that's the business.
30 shots in the clip like what's the business?
Arguing with the judge like that's the business.
You don't gotta choose it like what's the business? All my niggas on the job, what's the business?
Sob story in the courtroom, that's the business.
Tryna rob and you get dropped, what's the business?
Don't consent to being sentenced, that's the business.
You a walking stain, what's the business? I'ma hit your chest brain, what's the business?
Having stare downs with the judge, that's the business.
We be running like what's the business?
Dug my own grave in court, that's the business.
100 shots for a op like what's the business? Gang, gang, fun.
Intimidation tactics fail like that's the business.
On jumping off the chain like what's the business?
6 life sentence locked up was like what's the business?
I'ma pull up with the yay like what's the business?
In the booty house forever, that's the business.
Eating lunch with the blood like what's the business?
Don't drop the soap in my asses, that's the business.
Hey, y'all double drum like what's the business? 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 What's the business?
Starting grounds, that's the business.
Business, what's the business? Bro say he needing pounds, what's the business? Hit my line when I'm in town, like what's the business? Heard they
Picking up soap in the shower, that's the business.
claiming this a drop, like what's the business? I'ma bring them round the mouth, like what's the business? Killing overflow, like what's the business?
Never seen the light of day, that's the business.
Killing for these hoes, like what's the business? Never leave without that pole, like what's the business?
Trying to suck up to the judge like, what's the business?
Blowing Cali out the door, what's the business?
Crocodile tears on deck, that's the business.
Stupid link on the cane, what's the business?
Pausing every sentence, that's the business.
I'm a guy, Charlemagne, what's the business? Pouring money, that's my lane, what's the business? Thumbing through a whole thing like, what's the business? Phone jumping off the chain like, what's the business?
Except for value, return for value, that's the business.
I'ma pull up with the yay like, what's the business?
That ain't my name, who is that, like, what's the business?
Eating lunch with the blood like, what's the business?
Lying to the cops and I'm on camera, that's the business.
AR double drum like, what's the business? 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 What's the business?
Reason for the sustain, what's the business?
What's the business? What's the business? What's the business?
6 life sentences, that's the business. 40 years old trying to rap like, what's the business? What's going on, peoples? What's going on? How's everybody doing this evening? Please make sure that you like, share, and subscribe to the video. And let me speak to everybody in the chat real quick. Hey, Coffee Cakes, Melody, Love Joy, Toby, Jason, Clown with the Knife. I like that, Clown with the Knife. Nail GB, Nail GG. Let me see, who else is here? I got everybody. Hey, Bright. Anywho's, I'm here with my little co-host, Paisley, but he's sitting down being quiet for once, so I ain't gonna bother him. But anyway, I'm here this evening to bring you, hey, Sister Mary. I came tonight to bring you part 2 of the Erica Patterson Darrell Showdown, which is from season from episode 12 of the trial. And also I'm going to read the complaint, which is the reason why he's in Milwaukee. Let's see here. Okay. So let me get to that real quick. let me set the scene. Let me play some music. This is going to be Master Bitch Theater. Cut my music down a little bit. All right, so here we go. State of Wisconsin, Circuit Court, Milwaukee County. State of Wisconsin plaintiff. Oh, again, the plaintiff. Brooks, Darrell Edward Jr. Criminal complaint. The below named complainant, being duly sworn on information and belief, states that count 1, felony intimidation of a witness. The above named defendant, between November 5th, 2021 and November 15th, 2021 at 949 North 9th Street in the city of Milwaukee, Milwaukee County, Wisconsin, knowingly and maliciously did attempt to dissuade EAP, who has been the victim of a crime, from causing a complaint, indictment, or information to be sought and prosecuted, and assisting in the prosecution thereof, where the act is accompanied by an express or implied threat of force, violence, injury, or damage, contrary to section, a bunch of numbers, and I'm not going to bore you with that. Upon conviction for this offense, a Class G felony, the defendant may be fined not more than $25,000 or imprisoned not more than 10 years or both. Well, bruh, I mean, you're going to be, what's another 10 years? Thank you, Bright. What's another 10 years to 1,000? What's 10 years? That's nothing. He can do that. Let me see here. Count. Did I read that? Okay, count 2. Felony intimidation of a witness by a person charged with a felony. The above named defendant between November 5th, 2021 and November 15th, 2021 at 949 North 9th Street in the city of Milwaukee, Milwaukee County, Wisconsin, being a person charged with a felony, did knowingly and maliciously attempt to dissuade EAP, a witness, from attending a trial or proceeding authorized by law in connection with that felony, contrary to section blah, blah, blah. So basically what that means is he was trying to convince her not to go along with the charges for him running her over. Okay. So count 3, bail jumping felony. The above named defendant between November 5th, 2021 and November 15th, 2021 at 949 North 9th Street in the city of Milwaukee, having been charged with a felony and released from custody under Chapter 969, did intentionally fail to comply with the terms of his bond, contrary to section blah, blah, blah. Upon conviction for this offense, a Class H felony, we're going down the alphabet, a Class H felony, the defendant may be fined not more than $10,000 or imprisoned not more than 6 years or both. So that's an additional 6 years. So that's 16 years we got. Y'all keep up with the amount of time. 16 years. Okay. Okay. Probable cause. The complaint is based on the written reports of sworn law enforcement investigators with the Milwaukee County District Attorney's Office, which were prepared through the normal course of police business, and when your complaining witness has relied upon in the past and found to be truthful. So Erica Patterson, it was found to be truthful. Yes. Okay, based on review of the reports pertaining to the investigation of this matter, your complaining witness believes that on November 5th, 2021, the Milwaukee County District Attorney's Office charged Darrell Brooks, 2/21/1982, date of birth in Milwaukee County, case with second-degree recklessly endangering safety contrary to Wisconsin statute, blah, 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 and felony bail jumping contrary to Wisconsin statute, blah, blah, blah. According to the criminal complaint in Milwaukee County, on November 2nd, 2021, the defendant got into an argument with EAP, during which the defendant punched EAP in the face. After punching EAP in the face, the defendant got into a red Ford Escape and drove away. Well. As EAP walked to a nearby BP gas station, that must have been that gas station that him and Magical Marcus went to, the defendant returned and struck EAP with the red Ford Escape, running EAP over. As a result of the defendant's actions, EAP suffered a dislocated left femur and a fractured right ankle. Y'all make sure that y'all are hitting that like and you are sharing and subscribing if you haven't done it already. Okay. Let's see where I was. Okay. On November 5th, 2021, an initial appearance was held on the criminal complaint in Milwaukee County. The court commissioner found probable cause and ordered the defendant to have no contact with EAP. The defendant's bail was set at a ridiculously, pathetically low $1,000 cash. The case remains open and is presently scheduled for a status of counsel hearing on December 20th, 2021. On November 3rd, 2021, the defendant called his mother, Dawn W., from the Milwaukee County Jail. During the phone call, the defendant discussed with his mother that the district attorney's office would need the cooperation of EAP in order to issue charges, stating they're going to need to talk to her and need for her to be a witness, and she's not going to do that. But she can get the charges dropped altogether if she talked down there So if she called down there and said, I didn't do what she said, the defendant further informed his mother, if she don't cooperate with them, they're going to have to drop it. One day later, on November the 4th, 2021, the defendant called EAP from the Milwaukee County Jail. The defendant used emotional manipulation on EAP in order to dissuade EAP from cooperating with the criminal prosecution. The defendant asked EAP, why did you do this to me? You know I love you. The defendant continued, listen. Please listen. I've come to realize that I'm not going to leave you, man. You have my daughter. I know your potential, what you can be. I want to marry you. No, the fuck he didn't. Oh. Okay. The defendant continued by emphasizing that he and EAP have a 16-year history, and the defendant is not finna play no more. Then the defendant asked EAP, will you marry me? Followed by the defendant telling EAP, you gotta call them people. 2.5 hours later, the defendant spoke with EAP a second time from Milwaukee County Jail. During the call, EAP asked the defendant, are you singing all of this shit just because? Inquiring whether the defendant was serious about getting married. The defendant responded to EAP by telling her he was serious, but because of this situation, there's a possibility I might not get out of prison, that I can die in prison, right? Oh, you know that's right. Your ass is going to die in prison. The defendant went on to tell EAP, I'm sitting up here facing 60 fucking years. You have to keep your mouth shut. The defendant continued this emotional manipulation by EAP by telling EAP the defendant would die in prison. And to think how bad that would make my mama feel. Think of how much pain that would be on her. This is all stuff you wasn't thinking about when you opened your mouth. The defendant stressed to EAP that when she spoke with law enforcement, EAP should have just said, I'm telling you nothing. On November the 5th, 2021, the defendant called EAP from the Milwaukee County Jail. During the call, EAP referred to herself both in the first and the third person, attempting to conceal her identity. Paisley, shut up! He killing the mood. I'm sorry, y'all. He killing the mood. Paisley, shut up! Oh, well, he'll be the background. I'm sorry, y'all. I'm sorry, y'all. Paisley losing his mind. Somebody got to be walking down the street or something. Anyway, I'm starting to say this something. On November 5th, 2021, the defendant called EAP from the Milwaukee County Jail. During the Paisley! Get over here! Get over here! Paisley! Get over here and sit down! Okay. Look, Paisley got on a little shirt that says security, and it's appropriate. Okay, anyway. On November 5th, Paisley! I'm tired of him. Paisley, get over here. You want a treat? Sit down. I'll let you sit in my lap and keep you from going to the door. Ooh, you annoying. All right, sorry, y'all. Don't be over here doing too much wiggling. You know how you do. All right, back to the Master Bitch Theater. On November 5th, 2021, the defendant called EAP from Milwaukee. Stop it! in the Milwaukee County Jail. Quit trying to bite my mic cord. During the call, EAP referred to herself in the first and third person, attempting to conceal her identity as the victim on the recorded call. EAP told the defendant, I tried. That's all I'm going to say. I talked to people and tried. EAP continued, yeah, I said everything. I said a lot. It had nothing to do with you. I said, nothing happened. I said a lot. Just know that. As the call continued, the defendant pretended he was not speaking directly to EAP, stating, long as they know, I'm not having anyone contact her, myself. I'm not trying to have no third party thing. EAP informed the defendant they want her medical thing, meaning records, to which the defendant responded, no and no. She has to show zero cooperation. That means no. The defendant reiterated, right, nope, I'm not giving you no medical records. No, she needs to stand firm. She can't let these people talk her into anything. So November 6, 2021, one day after the initial appearance held, God dog it, Paisley, you will spoil a wet dream. Let's move. Can't sit still. Anyway, on November 6, 2021, one day after the initial appearance was held in Milwaukee County, the defendant called EAP from the Milwaukee County Jail in violation of the defendant's no contact order with EAP. During the phone call, the defendant and EAP discussed law enforcement's request for EAP's consent for access to her medical records in order to establish the injuries EAP suffered as a result of the defendant running EAP over. The defendant told EAP, tell them no, I'm not signing over to give you the medical record. I'm not cooperating with y'all. I'm not coming to no court. The defendant continued, once she tell them that and keep stressing that and staying firm, they got no choice but to drop the case. So during the call, the defendant blamed EAP for the defendant's predicament. I hope she realizes the mistake she made. I hope she realizes what she did, and I hope she never do anything like this stupid again. On November 7, 2021, the defendant called EAP from the Milwaukee County Jail. On the recorded call, EAP informed the defendant that she was now returning calls of the district attorney's office and that she informed the district attorney's office that she see him incarcerated and that she was drinking during the incident. See, Darrell always talk about her drinking. And she gonna say that she was drinking, man. She said that she was drinking. Hey, Marquise. Hey, Donna. Yeah, Paisley might be lurking around. Oh, yeah, with the shock devices. Yes. Anyway, the defendant responded to EAP by telling EAP that's not enough, and that EAP should have told them he didn't do anything, that it was all made up. EAP responded, she did say she fell and tripped and he did not do it. In response, the defendant informed EAP that she was supposed to tell them that everything, the statement was a lie, all that. That's what she was supposed to say. So they're talking to each other in the first and third person. It's really weird. During the call, the defendant said, I can have no contact to tell anyone what to say, because that's going to be bad for me. Even though you're talking to the girl, but you can't have contact with her. And y'all on recorded line. Y'all stupid. Hold on 1 second. Let me mute real quick. Okay, sorry about that. Oh, I'm not gonna move my mic. Okay, sorry about that, y'all. Let's get back to business. Back to the Mystery Bitch Theater. Okay, that's better. Shoot. All right. Let me see where I was here. Hold on, I lost my place. Let's see. She don't want to see me incarcerated. Okay. During a recorded call from the Milwaukee County Jail placed by the defendant to EAP on November 8th, 2021, the defendant repeatedly blamed EAP for the defendant being charged in Milwaukee County case. The defendant started telling EAP, "You don't say anything to me, encouraging me at all." To which EAP responded, "Is it all about you right now? Because you know what you did too, right?" In response, the defendant blamed EAP. "Okay, and what did you do to cause it?" The defendant pressed further. "You trying to make it seem like everything is always everyone else's fault but yours. Like you don't never do anything to cause shit. And the whole cause of this shit was something that you fucking did." The defendant ended the call by telling EAP, "You did this shit and you couldn't even keep your mouth shut. After numerous people told you that shit. This ain't the place for you to be doing this shit. And you still ran your mouth. And I'm the one sitting in here facing all this time." EAP responded, "I'm the one trying to get you out, right?" To which the defendant responded, "You need to learn to shut your fucking mouth. Fuck you then, bitch." Well. What, y'all can't hear me? Can you hear me? Yeah, I lowered my music volume. So y'all good? Okay. Just want to make sure I cut my music down. So did y'all hear the part where he calls her a bitch? Okay, y'all heard that part? Okay. All right, so next page on Master Bitch Theater. Okay, in a second phone call between the defendant and EAP on November 8th, 2021 from Milwaukee County Jail, the defendant started the call by telling EAP, "If I tell your bitch ass to call my mama hoe, that's what the fuck you do. And if that's the case, if you don't give a fuck about me, then I can have my family get on your ass then." The defendant continued to blame EAP for the defendant being in custody. "I'm here because you can't keep your mouth shut." On November 11th, 2021, the defendant called his mother, Dawn Woods, from the Milwaukee County Jail. During the beginning of the call, the defendant appeared worried that he could not reach EAP. The defendant told his mother, "You know, you get your bail money back anyway, but still, I'll make sure that she do what she says she gonna do." Dawn Woods responded, "Because EAP ain't cooperating, they don't have a case." To which the defendant responded, "Yep, they're going to have to throw it out." So during the same call, the defendant's mother described EAP's recantation, in which EAP claimed that she fell in front of the defendant's car while he was trying to pull away. A response to the defendant said, "Why in the hell would I just try to mow her down knowing I could kill her like that?" Yeah, I wonder. On November 15th, 2021, the defendant called EAP from the Milwaukee County Jail. During the call, the defendant berated EAP for not helping post the defendant's bail. "You didn't put a cent on my bail. Why should someone else have to pay for some shit you caused?" EAP informed the defendant, "Well, you tried to," but before EAP could finish, the defendant responded, "Nah, I didn't try to do anything, because if I tried to do something, you wouldn't be on the phone now. That's what you're not realizing. If I tried to do something to you, you wouldn't be on the phone now. If I would have told motherfuckers go do something, you wouldn't be on the phone now. So don't tell me what I tried to do, because at any given time, it wouldn't be on try. It would have been successful." The defendant continued, "You ain't know who I am by now? You ain't know my little niggas is going to do what I tell them to do? Do you understand my people are going to move how I tell them to move?" EAP responded to the defendant's perceived threats. So you about to do that to me? The defendant responded, do you understand that? EAP responded, yes, I do. And another phone call placed by the defendant to EAP from the Milwaukee County Jail on November 15, 2021. The defendant chastised EAP for continuing to talk with the district attorney's office. You still talk to the people? You still talk to them when they call dumbass? You ain't supposed to communicate with them at all. EAP responded, I'm not. They haven't been calling. They've been emailing. In response, where am I at? They've been emailing. In response, the defendant told EAP, bitch, shut your motherfucking mouth. You still can't humble yourself. So if you still talking this dumb shit, I'm going to do it for you. Either way, you're going to do it yourself and bow down, bitch, or I'm going to make you. Now, which one you want? The defendant threatened EAP. You acting like you got so much motherfucking protection like you safe. Bitch, you on my motherfucking turf. Remember that. On November 30th, 2021, Milwaukee County District Attorney's Office investigators, blah, 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 and blah, 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 met with EAP. EAP verified the defendant called EAP while the defendant was in custody at the Milwaukee County Jail. Initially, the defendant told EAP that the defendant loved her on the phone calls. The defendant also made EAP feel guilty for the defendant being in jail and charged in Milwaukee County. EAP confirmed being afraid of the defendant because the defendant threatened EAP's safety and security. According to EAP, the defendant knows a lot of people in Milwaukee who the defendant could employ to harm her. During the jail calls, the defendant instructed EAP on what EAP needed to say in order to help the defendant. The defendant instructed EAP to not say anything, to refuse to allow law enforcement access to EAP's medical records, and to not cooperate with the prosecution, including by not appearing if required. Investigators, blah, 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 played portions of some of the recorded phone calls referenced above to EAP, who positively identified all the voices involved. So during the above time frame, the defendant was out of custody on $500 cash bail in Milwaukee County, when the defendant was charged with 2 counts of second-degree recklessly endangering safety, contrary to Wisconsin state statute, and 1 count of felon in possession of a firearm, contrary to Wisconsin state statute. That matter remains open, along with the defendant's condition of bail that the defendant refrain from engaging in any further criminal conduct. Well, I think he failed. Hey, Kayla. Anywho's, that is the criminal complaint. And that will be the end of Master Bitch Theater. So now I'll go ahead and play this fool. And I am using the video by, I know a lot of people, I know Coffee Cakes be over there. Mushmouth Joe. I've been listening to Mushmouth Joe, his streams, because he cut out all of the stupid ass, all the stupid breaks. You know, they break like 40 times. So they cut out all the stupid breaks. And his petty is on 1,000. I'm going to post his link in my description and in the chat. But his petty is on 1,000. I was listening to him because I sleep, because I have a husband who snores a lot and it's really agitating. So I listen to with my headphones, and I used to listen to Jody Arias. But since the Darrell Brooks mess came out, I've been listening to him. So, of course, if I'm going to sleep and I'm unconscious, and, you know, we'll get a few hours of foolishness and then it'll be silent. So then they done took one of them stupid ass breaks. So I start hearing my husband snore, and it wakes me up out of my sleep. So Mushmouth has cut all that crap out. Now he does play music a lot, because I was listening to, I don't know what day it was, but he played some song and it was real loud and it scared me to death. He scared me to death. But yes, so I'm gonna post Mushmouth in my description, and I'm gonna also put his link in the chat. So if y'all have not gone to Mushmouth, definitely check him out. Oh, wait, it's not. Hold on. Yeah, I gotta do it this way. definitely check Mushmouth out. And look, and I was on the fence about, you know, liking him or subbing to him because he said that he's a MAGA person. So I'm scared of them type of people. But if you're making fun of Darrell Brooks, you all right with me. I think that he's just a troll. So I won't hold it against him. Paisley, where's this dog? Paisley. Anyway, let's go ahead and get the party started. I'm so sick of this dog.
All right, thank you. Any cross?
No, Your Honor.
All right, thank you, sir. You may step down.
May have something later for that particular witness.
All right, I'll try to raise that on an appropriate break. Call your next witness, please.
Is there only one witness left?
Yes. For that, yes, for that time. Yes.
No one else is here?
No, it's not 10:30 yet.
Who's supposed to come in 10:30, Your Honor?
Stop it!
Call your next witness, please. I don't have that list right at my fingertips.
You said what happened?
I don't have that list right.
Look at his freaking face. Look at his face. And see, the thing about this that kills me, you say you're a peace-loving MAGA girl. Hey, G5. Well, you know, okay, well, love is, we all have love here. So if you a MAGA person, you know, fine. As long as you don't, you're not storming the Capitol, you all right. Oh, Lord, there's a bunch of MAGAs in here. Well. All right. Well, welcome. Yeah, this is not a political thing. It ain't a political thing. This is Darrell dumbass Brooks. And I think everybody from across the aisles can get along and agree this is a dumbass. That could be our one commonality. This is a dumb ass. But if y'all remember, the day before, at the end of the day, remember the prosecution is going to serve this bitch's subpoenas. But he's like, I don't want to put him in any order. And so the judge said, because you're not cooperating, you know, you're going to have this amount of people at 8:30, this amount of people at 10:30, blah, 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 blah. And so she was in that first block. Now, he didn't write down this list, right? Didn't write it down. So he over here looking stupid. Hold on, let me make this bigger so you can see his face. He over here looking stupid. And got this sense of entitlement. Like, you know, y'all should have the list and do exactly what, you know, try to intimidate and control the whole scene. But anyway, let's continue. I'll be quiet.
At my fingertips, but I know there's a witness available, so please call your next witness.
Can I be provided that 10:30 list?
Can y'all be provided the 10:30 list? You still on the 8:30 block. You want Erica to wait all day for your bitch ass.
You're so stupid!
Does the state have that? You can pass it over. I don't have that at my fingertips.
Sure, let me jot it. I have it, but I'll write it up for Mr. Brooks to review, Your Honor.
Thank you.
I set for value in return for value this paperwork.
Shut up.
Please call your next witness.
And who determined this order?
You bitch!
Mr. Brooks, I'll take up that issue outside the presence of the jury later. There's a witness available. Please call the witness.
That's not the witness that was intended to be called at this time.
I understand that, sir. Under 906.11, I have the authority and the discretion on that. So please call the witness who's available.
So I'm being rushed to judgment.
Call.
No, sir. I'm trying to have an effective and efficient use of all of our time. So please call
Which
witness.
Which is respected.
You
but
respect
at
nothing.
the same time, being this is my time
Right,
to
I'm going to
present my
excuse the
defense.
jury for right now. I'll rise for the.
He really think that he's an attorney. He really decided to go and watch some SBU, some Matlock, some Murder, She Wrote, and he thinks that he is really an attorney. He thinks that he's really an attorney. The Darrell Brooks School of Law.
The jury, please. All right, thank you. Be seated. Mr. Brooks, under 90611, I do have the authority and just my inherent authority over this case to
90611.
require you to call the next available witness. You, in my opinion, were not entirely cooperative yesterday with the process. And so I told you that 3 witnesses would come in at 8:30, 2 would come in at 10:30, 2 would come in at 1:30, 2 would come in at 3:30. And then if there were any left, I wasn't sure if there were or not, would come in at 4.
You also didn't provide me with that list.
You were advised on the record.
But
Look, this is what annoys me about him, right? So he's something, you didn't provide me that list. Why can't you write it the fuck down? You have long ass Nosferatu nails you could have used. You got the little pen, your jailhouse pen you could have used to write it down. How come you can't write it down? Now you can do all these ICF forms and you can do all of these complaints and requests for shit, but you can't write down your own witnesses for your own defense in your trial with 1,000 years on the line. Are you serious? Look, I still watch this trial every day. Yes, Melody, we're all still watching and laughing. Like, y'all make sure y'all hitting that like and you are sharing and subscribing, por favor. I'm not trying to make you donate, but hit the like, it's free. All right, let's continue.
Sir,
you didn't provide it to me.
Sir, you chose not to write down.
Look at his
So
face.
that's on you, not me.
Nah, that's
So,
no. You
here's
can't.
the
That's
thing.
a rush.
Patterson is here, so I'm advising you that she will be the next witness that you call if you so choose. If you choose not to call her right now, then I'm releasing her from the subpoena. Because we have almost 45 minutes until 10:30, just slightly under that. And there's no reason for you not to call her. She's on your list. She was on the listing, as I understand it, the groupings of 3, Tuesday morning, Tuesday afternoon, Wednesday morning, Wednesday afternoon, and so on and so forth. That's the order. I told you very specifically, I'm not going to have everyone come in at one time because that's not efficient, that's not effective, and it's not courteous to them. People have families, people have jobs and other responsibilities.
Well, honey, you know he don't give 2 shits about none of that. A person with no job, who doesn't give a shit about his children, with no well, he got responsibilities, but he just ignores his responsibilities. He don't give 2 shits about none of that. About some decorum and being mindful. Him? No, ma'am.
And we're trying to be mindful of all of that as well, while having the state assist you in getting these people here. So I'm advising you that if you don't call her right now, you will forfeit your right to call her.
Uh-oh.
Law.
Sir, I believe I have the authority to do that. She's here. She's ready to go.
Hold on. I want to see that face. Hold on. Let me back this up a little bit. That facial expression was great.
And there's no reason for you not to call her. She's on your list. She was on the listing, as I understand it, the groupings of 3, Tuesday morning, Tuesday afternoon, Wednesday morning, Wednesday afternoon, and so on and so forth. That's the order. I told you very specifically, I'm not going to have everyone come in at one time because that's not efficient, that's not effective, and it's not courteous to them. People have families, people have jobs and other responsibilities, and we're trying to be mindful of all of that as well, while having the state assist you in getting these people here. So I'm advising you that if you don't call her right now, you will forfeit your right to call her.
Is that lawful law?
Yeah, y'all see his face. He's developmentally delayed right here. Is that lawful law? Is that lawful law? Yeah, he wanted Erica to wait all day because he still is upset and think that all of this is her fault. Oh, well, thank you, Kathy. And I don't know what lawful law is. I thought, well, I mean, I guess technically there could be some unlawful laws philosophically, but yeah, I don't know what this is. Some sovereign citizen foolishness.
Sir, I believe I have the authority to do that. She's here. She's ready to go.
I'm just
She's
asking
your
the question.
witness.
I'm just asking the question. Is that lawful law?
It's like he smells breath and he's disgusted with it. That's why he keeps, like moving back and stuff. He smells his own breath, or he smells his own body odor because they don't bathe but like 2 times a week in the jailhouse.
I have the authority under 90611 and other rules and the inherent authority of this court to control the order and mode of interrogation.
Your Honor,
of witnesses.
why is it always so hard to just say yes or no?
Yes.
Is it?
I know you're not talking. Why is it so hard? Look at this. You know what's gonna be going in here, right? Yeah, I know when Bubba and them get him, what's gonna be going here? Right here. Right here. Assume the position. Oh, yeah. This is a person who cannot answer a straight question. Hey, do you want water or do you want Coke? Well, what is the definition of water and Coke? Why can't I choose Kool-Aid? Do you want water or Coke? Well, what is the problem with Kool-Aid? Answer the damn question. That's all I'm gonna say. Bubba them right here. Right here.
Lawful
I have
law.
the authority, sir.
I'm not disputing that.
You just
But that's what you're doing. You're arguing with the judge. You're disputing that. That's literally what you're doing.
Not disputing. No, I asked the question. Is it lawful law?
sir,
I love this. There you go. That's for the little homies right there. That's for the little homies. Everybody get a turn.
I told you what I believe my authority is. Okay,
You
if
told
you don't
me
want
what
to
you-
recognize it, that's
told
fine.
me
You
your
want to
authority.
object and note it, that's
told me
fine.
your
Your
authority.
objection
I'm
is
not
noted
debating
on the
your
record.
authority. I'm not.
So I will address one other issue with you because you said you had an issue regarding the last witness.
Look how slow he blinks. Is something wrong with him? Don't nobody blink that slow.
Which is fine. We can address that quickly. And then I'm going to have the jury brought and
Look at them gay ass nails. Look at them nails. I think his nickname needs to be French tips. Look at these nails.
that will be your opportunity to call
That's a
Ms.
misdirect.
Patterson.
That's a misdirect. What issue did I said I had with the
You
last?
said you wanted to raise
said-
an issue with about
What
Detective
I said
Guzman's
was
testimony.
I might have more questions for that witness. I didn't say it was an issue.
Oh, I didn't hear that, sir. You had your opportunity to ask the witness questions. He's been released.
Your Honor, if I mumble something under my breath, somehow that's audible, but when I talk clearly, somehow
I may have
nobody hears
missed
me.
it, but I heard what I interpreted was when you said I may have an issue with this witness. I didn't understand. I guess I didn't take that as you were going to reserve your right.
I mean, no respect for authority at all. But what it is he has no respect for women at all. He is over it. He's above it. Why is this white bitch telling him anything? Because he is the master. Who's the master? In his mind, and this big bubble head of his, he's the master. Hell out of here.
To recall him. So are you telling me you'd like to reserve your right to recall Detective Guth?
Yes.
All right, then that will be noted and we'll keep him under the subpoena. Now, that should address that. I'll have the jury brought back in and you should be prepared if you choose to call Ms. Patterson.
Really? What is this? She's not saying anything that you need to hear at all, right? Right? Nothing that you need to listen to. You on trial for 6 life sentences, but you're not listening.
And this is your opportunity to do it.
At the same time, though, that's still a rush to judgment, Your Honor. You can't. I shouldn't be forced to call people in the order that I'm being told to when these are my witnesses.
But you are in custody, and you can't get people to talk to you because you've got the prosecution's rejected witnesses as your prosecution witnesses, and I'll hate you. You got all the prosecution with you. You are the best witness yourself for the prosecution. Yourself.
You did not want to provide us with the order, and I respected that, Mr. Brooks.
But I said that.
And so then I asked
Your
you
Honor,
to put
with
him
all
in
respect,
flux.
with all respect, did I not inform Your Honor in the court that I would not give a specific order? I stated that numerous times.
And Mr. Brooks,
Numerous
I
times.
have authority to tell you otherwise. You
I
may
did.
not like it. You may disagree with it.
It's not
You
about
have
that.
been-
It's about the rush
You
to
have not been
judgment, Your Honor.
cooperating with this process. The
There's
state
nothing
has
to cooperate
graciously
with.
agreed to assist you given your custodial status.
Okay, and I never asked them to
frankly,
do
any
that.
attorney in this
I
situation,
never asked them to do that, Your
I never asked them to do it. I never asked them to help me, Your Honor, even though they graciously helped me. And they was telling me plenty of times, hey, dumbass, quit talking because you about to bring in other acts evidence because there was a pre-trial ruling and that you, for some reason, didn't remember that you had. And you kept asking people about November 20th, November the 20th, November the 20th. It never happened. Did it happen? It didn't happen. And then you are in custody. Now remember, ain't no subject matter jurisdiction. There's no physical, what is it, subject matter? There's no jurisdiction. But you are chained to a table with shock devices on, with shackles on. How are you going to get witnesses, since you're representing yourself, how are you going to get witnesses here if somebody didn't help you? The prosecution volunteered to help him and said we'll serve the subpoenas on his behalf. Oh, he got the pose again. You got the pose again. That's for Pookie. Right here, that's for Pookie.
Honor.
would give us the order.
Did I or did I not? Did I ask them to do that?
X.
I did not ask them to do that.
X.
They
No,
volunteered.
They offered.
So at the end of the day,
but we expect
if
your
they didn't want to do
cooperation
it,
in that.
yeah, but that wasn't one of the stipulations when they offered to do it, Your Honor. Let's
No, common courtesy is the stipulation.
okay,
sir.
but it
And
wasn't
here's the
stipulated
thing.
to, so I didn't have.
You are well advised of how this process was going to go.
No, I was not.
It is
Because
normal
if you-
in a trial.
You can't
to call
put the people.
witnesses
You can't
out
put the
of
people
order
in a
based on
specific
their
spot for
availability.
me, Your Honor. Come on now.
that it is.
That's a rush to judgment.
There's no rush to judgment here. You
Did
keep
the state
saying
did the
that,
state
sir,
have to
but
put
that's
their
not the
witnesses?
case.
Your Honor, with all due respect, did the state have to put their witnesses in order and tell me?
Bitch, the state is not incarcerated. You are. You can't serve your subpoenas. They can. Remember when they had that colloquy and the judge specifically said that the state is going to have at their fingertips these resources that you're not going to have. And you said that don't make me flinch none. They don't make me flinch one bit. So here you go over here bitching and moaning and complaining because somebody helped your dusty black ass.
It's irrelevant what the state did.
Did they have to do that?
They didn't need your assistance to do that.
Did they have
Thank
to do
you.
it?
No, they did.
I
not
didn't have to be
do it.
provided with we're going to call this witness at this time,
But they're
this
able
witness at this
to
time.
contact
They
their
didn't have to do that, so why should I have
and
to do that?
accommodate their schedules. This is not about you. It's not about the state. It's about the witnesses'
It's about what's fair.
availability.
It's about what's fair.
No, frankly, sir, it's about you trying to control what's happening in this court.
How am I controlling what's happening? I'm the one shackled to the table with
So here's the
with a shock
situation.
device
It is
on my ankles.
9:52.
So how's I'm trying to control anything? I just want this
I'm
to be
going
fair,
to
and it hasn't been fair.
Mr. Brooks, it's fair.
No, it's not. If I have to do something that they don't have to do, how's that fair?
They're not in jail, and they didn't run over 100 people at a parade and kill 6 people. That's the major difference. You are a defendant, not an alleged defendant. You're the defendant. Okay? That's why. That's the difference. They free, you in jail. You shackled to the table. They not.
It's fair.
Explain to me how that's fair.
The process that has been set up to frankly help you.
No, it's not helping me it's helping the state by being able to say, if we know the time and we know the person and we know this, then we can be prepared. So we'll already be ready.
Look, they're already ready. Okay, they're already ready. The stuff that you talking about, nobody in that courtroom were worried about your rambling, stupid cross-examinations that made no sense, that you didn't bother to pick up not one thing out of these boxes to read before you called them up on the stand. You calling people on the stand that you done killed, ran over 40 kids, and you calling them on the stand as your the defense witness, and you tried to kill their children? That's the shit you did.
That was the whole aim of that.
And I would have had her come in later. You didn't want to answer that question.
There was no question. There was no question to answer. I did what you asked me to do, Your Honor. You said yes, you did. You did. You asked me to give them my witness list.
Brooks,
I gave them my witness list. It's not my fault. It's not my fault they weren't gonna be prepared.
Boy, the arrogance. It's not my fault that the prosecution, who can actually pinpoint exactly what you're talking about, like he's reading from this report. They know this case that well. They've been that prepared and been preparing for over a year to prosecute your ass, but they weren't gonna be prepared. But you ain't prepared. You didn't write down one thing, not one question to anybody. You just winged it the whole time. So you over here whining and complaining. They go to pen in your hand. They go to the little pen in your hand.
Here's the deal. The jury's coming out, and I'm gonna stand my ground on this.
I'm gonna stand my ground too, but I'm not gonna be disrespectful or disruptive.
Your face is
disrespectful. I wanted to be fair.
When the jury comes back out, I'm releasing her from the subpoena.
You can't do that. Where's the lawful law? Where's the lawful law? I have the right to witnesses.
You have to cooperate with this process.
But I also have the Sixth Amendment right.
We have a witness available for you to call. I can require.
It's not the witness that should have been called at this time, Your Honor.
It is based on the list that you provided, and
that didn't have a time. That didn't have a time
I'm not going to play this game with you, sir.
It's not no game. That's what you don't seem to understand.
I believe that fully.
I don't care what you believe fully.
All right.
It's not a game. I don't take this as a game. That's what nobody. That's what nobody. You don't got to explain nothing to me. That's what you don't understand. You think that this is a whole game to me. This is not a game to me, Your Honor. Nothing about this is a joke. That's what y'all don't understand. And it's unfair. It's unfair and it's disrespectful to me that you think I would come in here purposely and treat this like a joke or a game.
I never said it was a joke.
What type of statement is that? Your life is not on the line. Mine is. And you think that I think this is funny?
I don't think it's funny whatsoever.
So I think, Your Honor, with all due respect, I think you should show some respect.
Take a 5-minute break, and when we come back, the jury's coming out, and you need to call your next witness. Thank you. We are in
No, you're not rushing me to judgment.
I don't care what you're talking about.
After a short break, Appearances are as they were before. I would just note Attorney Opper's not at the table, but I presume she'll be back shortly. I will be advising the clerk to have the jurors brought out. And then I'll ask you, sir, to call the defense next witness.
Can we address subject matter jurisdiction and still has to be proven for the record?
I decline to do so. Your objection is noted.
Is the audio on?
Your objection is noted for the record.
Is the audio on?
Yes, it's on, sir. It's on.
So we're not going to address subject matter jurisdiction that has yet to be proven for the record.
For the record, I have addressed it.
No, you haven't
And
proven it
there's
for
a
the
written,
record.
and your objection's noted for the
Have you
record.
proven subject matter jurisdiction for the record? Have you proven it? Has the prosecution proven it? So that's a judicial determination that you don't have to answer that, Your Honor.
So for those of y'all who know, subject matter jurisdiction is it's what they use for federal cases, or they use it for civil cases. So, like for instance, if I'm driving into Georgia and I have an accident, well, the accident, the crime is where the accident. So Georgia will have jurisdiction over, the accident, vice versa. Sometimes it can be with civil matters where there might be a federal question. There might be a federal and state court. And so there is an issue where you have to have jurisdiction. Usually it's the federal will get the jurisdiction, but it's a federal question. Maybe something about gun rights or something that might be a part of the state crime, or a certain dollar amount makes it federal over state. And so that's the subject matter jurisdiction. It doesn't have to be proven. It just freaking is.
Public servant.
I was talking to my clerk. I didn't hear what you asked. The jury's coming in.
You heard what I asked.
I actually did not.
He was like, look, Snowflake. You heard what I said, Snowflake. You heard what the fuck I said. And you need to bow down, bitch. And then what he told Erica? Bow down, bitch. That's what he's trying to do.
Come on, Your Honor. Come on now. We got to cut that out. You know you have to prove subject matter jurisdiction. You know that. You have to honor your oath of office. You know that.
OAF, oath.
Thank you, everyone. Please be seated. The defense may call its next witness, please.
Give 1 second. I'm trying to make sure I got the paperwork since I'm being rushed to judgment.
Go ahead.
Defense calls Erica Patterson.
Thank you. We'll have her brought in.
I'm being rushed to judgment.
Thank you. Please be seated. First thing I will ask you to do is to state your first and last names for the record.
Erica Patterson.
Thank you. Go ahead, your witness.
Oh, the one spelling the name?
I believe it's on the record from previously, but go ahead. You can spell your first and last names, please.
ErikaPatterson.
Just 1 second, Your Honor. I'm trying to find some relevant paperwork here.
So all he does is just shuffle papers around, just back and forth.
Sorry about that. 1 second. I'm trying to find this paperwork.
Just back and forth, shuffling papers.
Just have it on the table.
When you're ready.
I'm just going to start the questioning. I'm not seeming to find paperwork that I just had on the table for some reason. Odd reason.
Yeah, he did. Much
So,
mouth
good morning,
did do
Ms.
good.
Patterson.
Good morning.
So what do you do for a living?
I have my CNA certificate.
Oh, y'all know why he always asks people what they do for a living. He's copying the prosecution when they had the old when experts came up and they had to talk about what do you do for a living? How long have you been doing that? So he decided he's going to copy that and just ask everybody, what do you do for a living? Like it's relevant or something.
I'm going to direct your attention to
Ooh.
the evening
Don't she look mad as hell? Erica looked mad as hell.
of November 21st, 2021. Do you recall what you were doing that evening?
I was hanging out with my friend Corey at Frame Park. I had spoken to you, Mr. Darrell Brooks. You came out there at Frank Park and met me after Miss Corey separated from me with her friend. Me and you got into an argument.
Whoa. Pursuant to the question.
Pursuant to the question. The hell that mean? What does that even mean? I've never heard that. Pursuant to the question. Pursuant to the question. What does that mean? Like he done picked up some words that they said in the courtroom, and he was like, "I'm gonna make a objection. I'm gonna make one." Pursuant to the question.
I am answering your question.
I was referring to the judge.
I
think that kind of got a little ahead of.
Please, mommy, come bail me out. Come help me. I don't know what I'm doing, but I'm gonna play. I'm playing attorney, but I need you to help me, mommy. Help me.
Mr. Brooks, I'll let you interrupt the answer, and you can ask a follow-up. I apologize. I was instructing the clerk to turn up the volume. So go ahead.
The judge was not listening to your dusty ass. She, by this time, got so tired of your nonsense that she had other things to do. She was probably typing some emails. She was probably trying to pick out her lunch. You know, she always wanted to break for lunch. So she was probably picking out her lunch. She was probably shopping for Christmas gifts. What about listening to this shit?
Ask your question.
Same question?
Sure.
Yeah, sure, because I wasn't listening. So I don't know what you asked.
What were you doing the evening of November 21st, 2021, before linking up with the alleged defendant?
Alleged defendant.
Me with my roommate at the time at Frank Park.
And what were you and your roommate doing?
You covered this ground during her testimony previously.
Objection. And grounds. I object to that and grounds for the objection.
Ms. Brooks, we did.
Wait a minute. So objection. I object to that and grounds for the objection on behalf of the state. So you objected to the objection. Okay.
Did cover many of these topics previously. So if there's new topics, please go to those. I'll give you a little bit of leeway to lay some foundation, but go ahead, ask your question.
That's
the
what the
objection is from the state is overruled. Do you remember the question?
You asked me what we were doing at the park with Corey. Is that your question?
Yes.
We were drinking. I was drinking my card beverage.
Do you recall around what time of the evening it was when you and your
Thank you, Donna.
roommate
Have a good
arrived
night.
at the park?
I do not remember. We left where we were staying a little around afternoon. A little bit around afternoon.
Do you recall having any phone interactions during that time when you and your roommate were at the park?
Phone interaction, yes.
Do you recall who they were with?
You.
Your dusty ass.
What do you mean by you?
Darrell Brooks.
Brooks.
Is that usually the name you refer to the alleged defendant by?
No.
Would it be fair to say that during those phone interactions, there was a talk of you guys meeting up? Would that be fair to say?
Oh, God. Would that be fair
Yes.
to say?
Do you recall, to the best of your recollection, what time that would have been at?
No. I don't remember.
Thank you for coming,
It
Donna.
was throughout the day.
I'm sorry, are you making references to the phone conversations being throughout the day?
Yes.
And so at some point, would it be fair to say that you did meet up with the alleged defendant?
Yes.
Do you recall what time that was?
I just told you no.
Do you recall if you were still at the park during that time,
Eggplant
or had
lady.
you moved locations?
Still at the park?
And was your roommate still present with you at that time?
No, she left. We went separate ways. I stayed at the park and she went her other way with her friend,
Do you recall who that friend was?
Nick.
I'm assuming, or let me back that up.
Backed it up.
Would it be fair to say that at some point during the meetup with the alleged defendant, things got a little chaotic. That'd be fair to say?
Yes.
And do you recall if at that point you were still at the park?
When we met up,
Yes.
well, we were at the park for a second, then we drove around.
Where did you drive to?
Around, then me and you, Mr. Brooks, were arguing in the car. We went up this. It's a street. It's like a hill. Went up there, and then me and you got into an altercation. I got out of the car, walked back towards Frame Park.
Oh, wait, again.
Hold on, she's answering your question.
Um,
You asked her where you drove around. Go ahead.
What?
And
yes, ma'am. And then I was walking down the street, and I left your car. And that's when you followed me, and I walked back towards Frame Park. And you were following me.
Yeah, he was stalking
No
her.
reference to walk back to Frame Park.
I don't know the exact street name. It was the walk back down the hill. I don't know the exact street name.
Did you at any time, sorry,
Choke on them lies.
did you at any time during your travels back to Frame Park, did you at any time notice that there was something going on in the area?
No. When I got to Frame, I was too worried about walking back to Frame Park. When I got to Frame Park after I left it, that's when I realized there's something going on.
And did you ever arrive back at Frame Park?
Yes,
And what did you do when you arrived back at Frame Park?
I called my friend Corey and told her that me and Mr. Brooks got into an altercation. Mr. Brooks was following me. I went back to the SUV, the car, and you argued with me somewhere. I walked back across the street, and by that time, Miss Corey had walked towards us to meet up with me.
Reference to you calling your friends.
Mhm.
Do you recall? Well, let me back up a little bit. Did you call your friend Corey or the friend that she had left you to hang out with?
Corey's phone, I kept calling her phone. Her phone kept going to voicemail, and I called Nick's phone. He put Corey on the phone. I said, Darrell Brooks had just hit me.
I'm going to back up a little bit, if I may, to the day prior, November 20th of 2021.
Now, if y'all remember, November 20th, 2021, there was no physical evidence that he struck her. That's the only reason he was charged a 77th charge for the what happened on the 20th. But y'all remember the interrogation with the carpenter and the other guy. They said that there was evidence to support that charge. So, but he wants to continue to argue about the 20th, the 20th, the 20th. Forget the parade, forget the folks I ran over, forget the little boy that I killed, the grandmother and the teenagers that I ran into. November 20th. November 20th.
Do you recall what you were doing that day?
Well, where I was staying at the shelter at first, I was arguing still with Mr. Brooks all throughout the day. Me and Corey had left, and Corey and I stepped away, and I went back to Frame Park. On the Frame Park, that's where I met you at. Me and you also got into argument that day, but we didn't drive around. We're at the Frame Park.
So you're saying that you and the alleged defendant were together the day of November 20th, 2021?
Yes,
Do you recall around what time that was?
I do not remember.
They were taking a walk around the park after dark. Let's take a long walk around the park after dark. Maybe.
And you stated you were briefly with your friend Corey that day?
Yeah, but she went a whole different direction. She didn't come to Frame Park with me. She turned on a whole different street right before Frame Park.
Do you recall at any time on November 21st of 2021 being interviewed by a Detective Guth?
Yep.
And do you recall giving a recorded report at that time?
I don't remember.
Do you recall if you had given Detective Guth all the details of the alleged incident on November 20th of 2021?
I didn't give him all the details, but I did the next day when I seen him.
Funny. Were you
Funny.
aware that it was reported there was in fact no incident on November 20th, 2021?
That's not true.
Objection, move to strike the answer and the question.
Grounds.
Lack of personal knowledge, hearsay.
Sustained. I'll strike the question and the answer. The reason stated, sir, rephrase, or
So can I show the witness that same paperwork that I attempted to show?
no,
And why not?
That
not relevant.
How's it not relevant when that was just testified to? Wouldn't that be opening the door?
No. Next question.
Any reason why it would be reported no incident happened on November 20th of 2021?
Same objection.
Grounds.
Since facts not in evidence, sustained.
Grounds for the sustain.
Substain. SUB stain. Substain.
Detective Goof, during the first interview, do you recall why you were not forthright with information?
It wasn't that I was not forthright, I just didn't tell him everything right away.
Why not?
I don't know, Mr. Brooks.
When speaking with a law enforcement officer, would it be fair to say that you should be truthful and honest?
I was very truthful, I just didn't tell him everything at once. Told him the next day, Mr. Brooks.
And in the alleged incident on November 20th of 2021, were you injured?
Well, you did hit me a little, both like a little.
Were you injured?
No, I didn't have any marks on me. Is that what you're asking?
So where were you injured?
Look, what type of shit is that? So were you injured? Were you injured? You slapped her. But where were you injured? Remember in the interrogation, he would say that you saw her. She don't look, beat up. She don't look beat up. So where were you injured? You hit her. That's why she was injured. You didn't deny and say, I didn't hit you. You just said, where were you injured? Stupid.
By my lip.
Objection. States the evidence.
Grounds.
I believe the witness understood the question. She answered it. It may stand.
Did your roommate observe any injuries from the alleged incident on November 20th, 2021?
Oh, look at her. She
She knew
mad.
about it. But there's nothing visible on my face.
Do you know if your roommate had spoken with law enforcement about these alleged incidents
I
from
don't know.
November 20th of 2021 and November 21st of 2021?
I don't know.
Did she ever tell you yourself that she was interviewed by any law enforcement?
I don't remember.
So what time did you meet up with the alleged defendant on November 20th, 2021?
I don't remember.
Morning time? evening
Afternoon.
time? I didn't hear that.
Afternoon.
And what were you doing prior to the alleged meeting up with the alleged?
Wash your ass. Who cares?
Grounds.
Asked and answered.
Sustained.
Grounds for the sustain.
Asked and answered.
When?
Look at his
Next question,
face.
please.
When was it answered? So to the best of your recollection, you can't recall why an alleged incident on November 20th of 2021 was reported to never happen.
Objection.
Grounds.
Same reasons as the previous objections.
Since facts not in evidence, mischaracterizes her prior testimony and irrelevant.
I object to that respectfully and
Next
ask for a
question.
legal finding of fact and a legal reconsideration of that ruling, Your Honor.
Denied. Noted for the record. Next question, please.
I'm trying to figure out how something got pulled out of thin air.
Oh, here you go. He's looking. Oh,
Interesting.
look at him. He's like, I'm ready.
So it would be fair to say that you have a child in common with the alleged.
I'm finna get this
Fair to
bitch.
say.
Yes.
Yeah, is that the only child?
Yes.
You have any other children?
Objection.
It has
Grounds.
nothing to do with the case. Sorry.
Hold on, there's been an objection. Not relevant. Sustained.
Grounds for the sustain?
The record speaks for itself. Next question.
What was the record speaking for itself? I didn't hear it.
Not relevant.
How's it not relevant?
Please.
How's it not relevant?
Come on, man.
The child that you have in common with the
Alleged defendant.
how old is that child?
15.
Do you keep regular contact with that child?
Off and on.
Describe what you mean by off and on.
I'll object.
Grounds.
This is not relevant.
Not relevant. Sustained.
Grounds.
Ooh, she mad.
It's not relevant, sir.
She answered it.
Look at Dopey the dog, deputy dog. He's so freaking stupid. stupid.
Next question, please.
And the child in common that you have with the alleged defendant, does that child live with you?
No.
Objection.
Grounds?
Relevance.
Grounds.
Sustained, not relevant. You don't have to answer that.
Do any of your children live with you?
Bitch, do any of your children live with you? Hey, when's the last time you paid child support? Don't you have warrant for delinquent child support? Man, please. I wish I could have been there. I wish I could take over Erica's body. And I would have been like, I know your motherfucking ass didn't. Just say that. And then look at his face. He's like, yeah, I got her. I got that bitch. I got her.
Objection.
Grounds.
Relevance.
Sustained,
Grounds for the sustain?
not relevant.
That goes to credibility, Your Honor. So how's it not relevant?
The objection has been sustained.
Look at him. Look at his face. He's over here smiling. I think he's flirting too.
For relevancy.
I hate him. I hate this bitch. I hate him.
I object to that and would like to inform you that I intend to appeal that decision unless you want to give a legal reconsideration of that ruling.
Noted for the record. I direct-
Oh, you know what? I'm sure the Judge Darrell was so afraid that you're going to appeal this decision. And, you know, you're trying to threaten her. So she'll go, oh, well, to keep you from doing that, go ahead, Mr. Brooks. Go ahead. Ask your irrelevant, stupid-ass question. If anything, you're opening the door, not her, you, like you already did earlier with the detective. Was it? Yes, no, it was the day. It was on the trial day 11. We opened the door, kept asking questions about that freaking picture and the video, and then they pulled out a new exhibit and played the entire video on your dusty ass.
Direct your attention to 906.16, and the basis for the objection being sustained is it does not fall within the categories listed. Next question.
Is that lawful law?
Next question.
There you go.
I'm getting there. This is lawful law.
Wisconsin State Statute 906.16.
That doesn't answer my question, but okay. Where did you meet the alleged defendant?
Reno, Nevada.
How long have you known the alleged defendant?
16 years.
You made reference to me.
Then the longest 16 years of your life, hasn't it? This has been the longest 16 years of your life. You probably feel like it's been 30 years dealing with this fool.
In Nevada. Do you recall where you met at? In Nevada?
No,
Who cares?
I remember.
In relation to the alleged incident on November 21st of 2021.
Oh, we're going back to
fair
21st.
say that there's been no contact between you and the alleged defendant?
Not since then, no.
That last answer was kind of low. Did you say no?
I said no, not since then.
So that would mean, assuming that would mean no contact at all via phone or anything like that.
No.
So my question would be, I don't know if you could see them from here.
Uh-oh.
Do you recognize these pictures?
You need to show those to the state. The business.
Look, Zach is mad. And Arthur is like, what the hell is this? Zach is mad.
That's not proper procedure, sir.
Yes, Zochi. He's definitely lying.
I'm going to object to what's being shown as a witness. They have no relevance whatsoever to this trial.
Yes, they do. And I'm
Sustained.
getting to how they have relevance.
They've also never been disclosed to the state before this moment.
Sustained.
Sustain why?
Not relevant.
They are relevant. It creates foundation.
No, the hell it don't. You don't even know what you're talking about, creating foundation. You don't know what the hell you're talking about. She's not an expert witness.
And I can prove that.
I'll take up the issue outside the presence of the jury at the conclusion of this witness, and if need be, bring the witness back in. But next question, please.
And these need to be offered into evidence as well.
They need to be offered into evidence as well. Bitch, you better get these pictures and offer them into evidence. This is my evidence. This is a defense of me running over 6 people. I'm sorry, hundreds of people and killing 6. This is my defense. November 20th, 2022, and this baby, my baby's baby, This is his big, smoking gun, I mean, he pulled them shits out. Like, I don't know if any of my white friends is here, but if you ever played spades or anything with some black folks or dominoes, and it's like a big production, we pull the cards out and we just get it, and it's just like, we flick it, bitch. That's what he did. If y'all have not been around some black folks playing cards, you really should. It's an experience, and you'll have a good time.
You stated that there's been no contact. How would the alleged defendant obtain photographs from you if there's been no contact?
Objection.
Grounds.
Back to non-tenant.
Grounds.
Sustained.
Grounds.
That's not evidence. Not relevant.
How's it not relevant?
Thank you, Melody.
Photos just don't pop up out of the blue.
Mr. Brooks assumes facts not in evidence,
No,
and at
facts.
this point,
I got the pictures
conduct
right here.
after
Facts.
the alleged date of violation here, it's not relevant.
Alleged violation.
You're
For the record.
correct. After the date charged, that the dates that are charged for these allegations, you are absolutely correct.
Bitch, that's what she said. That's exactly what she said. It's an alleged allegation, alleged incident. That's what the fuck she said. But you want to argue. I mean, you'll argue with your shadow.
Thank you. Have you, since the evening of November 21st of 2021, have you attempted to contact the alleged defendant?
Objection.
Grounds.
Relevance.
Grounds.
I'm going to excuse the jury.
Look at his face.
I'll rise for the jury. Thank you. Be seated.
He think he did something. He think he just done broke the case wide open. He done did something. Look at him.
Oh, funny. Your Honor, I find it.
Hold on. All right, sir, I'm going to let you make an offer of proof as
Now, if y'all didn't hear, he was going, ooh, wee. So my my white friends, when you hear, ooh, wee, that's us saying this is some hot tea. Well, y'all may not know the expression of hot tea either. But this is some big shit here. And I got his motherfucking that. Ooh, wee. Yes, exhibit A, a baby, motherfuckers, a baby.
to why you believe the photographs and the questioning about contact after the alleged incident is relevant.
It's relevant because these by the witness.
It assumes a fact, not an evidence, but
You
what
want
is,
the letter
hold
too?
on. Tell me the basis you believe there's been communication and why you believe it's relevant to her testimony.
It's relevant because it was testified to her first time testifying, and then also by was the last guy, Goof, that he was told that the witness was supposed to be so deeply afraid of me and all this type of stuff. So if you're so deeply afraid and worried about somebody and this and that, why would you sneak and have
Do you want
contact?
to open up the door to the other act's evidence of
That's
you
not
used-
opening.
No.
That's not opening the door.
Yes,
Hear
it
me
is.
out. Oh, yes, it does.
No, it doesn't.
These witnesses have been incredibly careful to abide by my rulings. Sometimes in a court of law, when there are pretrial rulings, the testimony of a witness needs to be said in such a way not to run afoul of that. This witness, Detective Good, I believe Detective Casey and others, Corey Runkle, and even Nicholas Kirby yesterday, this court has all had to stop them so that they didn't run afoul, or they've stopped themselves so that they didn't run afoul of the court's pretrial ruling on other acts evidence between you and this witness. And I have been very, very careful to make sure that doesn't come in. But if you keep questioning her about whether she's afraid or not, or why she wouldn't have contact or not, you are opening the door to that testimony. All of my rulings have been made to prevent what could be seen as prejudicial evidence. The standard's not prejudicial. The standard's whether it's unfairly prejudicial. But you can open the door to that, sir.
It's unfairly prejudicial.
Come on, get it right.
I have a document stating that November 20th never even happened, but yet and still the witness can get on the stand and lie on the stand.
Over to the state.
Come on, man. Y'all know that's not right. Y'all know that's not right.
Then you need to immediately turn it over to the state right now. It may become relevant, but no one has seen it. When did you receive the document? Hold on. When did you? I'm having you make an offer. But when did you receive the document?
Okay, but I just want to stay for the record, Your Honor, that's kind of biased because the state did the same thing yesterday with creating an exhibit right on the fly that didn't even exist that I didn't have. But
that's not true. That's a misstatement of the
that is true.
No,
she said it herself.
No. Marking an exhibit is not creating it.
No, not marking an exhibit. She said
we're not going to go down a tangent, sir. Right, I'm going to focus on this, and I'm going to give you the opportunity to make a record.
It's not
right.
It's perfectly fair.
It's not fair.
When
Erica is still on the stand,
receive this document that you claim was sent by this witness.
It's not claimed. It's for a fact.
For a fact,
sir. It hasn't been established yet. I need to make a record.
So y'all want
the letter? I want to see the letter. What? I want to see the letter.
Okay, so I got.
And I want to know when you received it.
I got to bring that in.
Yes.
Every time this is what I get. Every time I'm presenting something that needs to be made for the record and placed in the evidence, it's a problem. But the state can do it, no problem.
It's not, sir. There are proper procedures, and I want
because they know the rules of evidence. You hadn't cracked that book open once to learn about rules of evidence, cross-examination, leading questions, all that type of stuff. You hadn't cracked that book open not one time, not once. I mean, and there's a book, like literally, of procedures, criminal procedure, civil procedure, and it tells you all of this stuff. All of it.
That was the proper procedure.
If you don't make a record,
so
then
what?
I can't make a ruling.
It threw people off a loop. They weren't ready for it. They scared of it. That's what it is. Come on, man.
Mr. Brooks.
Come on, man. Stop.
When you
Stop
aren't
Stop it. You're a public servant, Your Honor. I respect your courtroom. I respect you. You're a public servant, though. Your job is to be the referee. Is it or is it not? Ooh. You stated so yourself on record that your job is being the umpire.
Your Honor, can I ask Ms. Patterson please be excused?
Yes, you can be excused. My apologies.
My apologies too, but it needs to be some truth, especially when we're talking about stuff that didn't even happen, but they're allowed to get on the stand and say that it happened when they know it didn't happen.
So I'm going to make a record about what he's referring to in count 77. Okay.
What happened to that paper? Because it was on the table. Then when Mr. I come
Brooks,
back in,
I need to make a record of a variety of things.
So who took my paper?
And you keep interrupting me repeatedly today. I have shown an abundance of patience this morning. I've warned you repeatedly about being removed from the courtroom. And then every time I try to get into it, you, meaning an explanation and make a record, you interrupt, you attempt to divert everyone from what is being done this very second.
I didn't attempt to do anything.
Yes, you do it repeatedly,
okay,
sir.
Whatever.
So you're doing it once again.
Whatever. Just make your record.
The document that Mr. Brooks wanted to show Detective Guth and this witness was a letter sent from the state of Wisconsin to the court regarding count 77,
which was dismissed.
The state sought to dismiss that count, and they have prosecutorial discretion, and I granted the request that the charge be dismissed.
Why was the charge dismissed?
And that's, I can't answer. It was dismissed because the request was made, sir. They don't need a reason. There's an abundance of case law about prosecutorial discretion, and they chose not to pursue that. My guess is maybe to simplify things and to keep this tidy. I don't know. You know what? I'll indulge you. Attorney Opper, would you like to provide a basis for why the state sought dismissal of that charge prior to the start of this trial?
Yes, Your Honor, because as Ms. Patterson just testified a short while ago, she did not have any visible marks or injuries from that event. And we did have the photographs of her injuries. We did not want to confuse the record as to whether or not there was a battery that occurred on November 20th.
Your Honor, I object to that. What does the letter read?
You have the letter. You showed it to me, sir.
And I've been trying to find it ever since I came back in here, and now all of a sudden I can't.
And now you're impugning, though, like somehow you're impugning the integrity of this court, of the bailiffs of this state. You're accusing, frankly, everyone of moving your papers.
Did I point the finger at anyone? Did I say anyone did anything?
Not directly, but indirectly you did.
So
sir.
How can you make the assumption that I'm saying?
Can I please make the record without you interrupting?
Yes, you may. Yes, you may. I apologize.
I appreciate that.
Oh, that looks so sincere.
But you made repeated comments, sir, about I can't find my documents, I don't know what happened, things of that nature. When you came back out, you took multiple minutes before you even asked your first question of Ms. Patterson. And if I need to, I'll have a bailiff put on the record that no one touched your table.
Your Honor, did I say anyone touched my table? I didn't say
you implied it, sir.
But did I say that?
You implied it.
I never
you stated it implicitly.
I never asked the bailiffs, hey, did any one of you touch my table? I never said that to them. I just said, I can't find my paper, which is the truth.
And the way that you said it, like,
I didn't point anyone out.
That's true, Andrea.
And like, well, that's kind of interesting. I don't have a document that was just on my table. That is what you said.
That's what I said, but I did not point the finger at anyone.
So
I
you
can see
have
if
the
I
letter.
came in, Your Honor, with
You've
all
been
respect,
given.
I can see if I came in and said, hey, one of you moved something off my table, or if I would have directed that towards the state, or if I would have directed that towards the clerks or something like that, then that would be more of a validity to what you're saying.
I need to continue with the record, sir.
Nobody cares about what you're talking about,
It's very apparent to me, sir, that every time, I can't say every time because that would be an absolute, but many times throughout this trial, and especially the last 2 days, when the court makes a ruling that you disagree with, or I want to make a record about some behavior of yours, or a further record about a ruling that you that was not in your favor, that you start peppering me with questions or comments, statements. You question me about the law. You ask, is it verified law? It is, from my perspective, a clear attempt to kind of turn us in a direction away from what we're doing, perhaps even to stall and to delay.
I'm sorry.
That's my perspective. That I'm making a rule. You're doing it again.
I mean, because it has no validity.
So,
ass clown.
I am trying to make a record outside the presence of the jury about a line of questioning you want to ask Ms. Patterson. Now, I've reviewed repeatedly up on the bench 90608 and 90616, which are two of the primary ways you can attack credibility. I've referenced one of those previously. 90608 is evidence of character and conduct of a witness. I'm not going to read through it all, but it's limited to character for truthfulness or untruthfulness. It's not specific instances of conduct. It's character evidence, which frankly wouldn't even come from the witness who's testifying. All right. Then there's the statute on bias, 90616.
She wasting her time. You wasting your time.
None of the questions, as I heard them, went to a permissible topic under bias of witnesses. You generally said credibility.
Judge Jennings, you are talking to your monitors. That ass clown is not listening to a word that you have to say. Not a word. You would think all this is going on, I'm going to go to those statutes that she's talking about and read it while she's talking. Nah. He's going to pull out a Bible and pretend to read it. Just hold it and not listen to anything that anybody says. And this has served you so well.
You did not give me any further explanation.
Hey,
as to why you believed it was relevant to credibility. We have you claiming that there's some document that was sent by the witness after the charges were filed that apparently contained photographs. I think, and you can clarify the record momentarily when I'm done, that you believe goes to the credibility of this witness. So I need to ask a few questions about that, sir, to determine whether it has relevance to those issues.
I like that twat
Number
waffle.
one, When did you receive this letter?
I received this multiple letters actually over a period of time.
Bitch, just answer the fucking question. She said, when did you receive this letter? The one that you got the pictures from. That's what she's asking. Answer that question.
It wasn't. I referred to this one because this one had the pictures.
That's the one she's asking about.
But
And why do you believe it was from Ms. Patterson?
To answer your question with clarity.
Thank you. Does it have a date on it? The letter?
No, I didn't bring the letter. I brought the pictures because I thought, from my interpretation, I thought showing the pictures would be okay. How did I get these?
Oh, I wonder how could you gotten them? Your mother could have sent them to you. That's just right off the top of my head. That little the little tubby larrikin that spoke at your sentencing, she could have sent them to you. Your grandmama could have sent them to you. Anybody, I don't know, Master P, Dr. Dre, Eminem, someone that's not her could have sent them to you. They probably came out of your fat ass. I don't know.
So my mind was saying, show the pictures.
Show the pictures.
They didn't come out of thin air.
Ah.
The witness knows that they sent me the pictures. They know that.
Well, again, it assumes facts that aren't here. You're assuming this witness sent it. I don't know. But even if she did, what relevance does it have to her credibility before this jury?
It goes to the credibility because she's put on this facade of being so afraid of someone, but yet still, you know that we're not supposed to have contact, but you still sneaking behind and saying, oh, I wonder how you're doing. And oh, this and this and that. Oh,
I don't think she's ever said she.
What a melodramatic queen. He is such a queen. And see, there you go. He's got some nice little dick suckers right here. Just right here.
She was afraid. I think that was the officers who may have stated that, but I don't believe she ever said that. She specifically said today when you asked her, why did you, it was either why did you go back? Or why did
waffle.
Get my notes. And
it
she
was
said,
why.
I don't know.
It was why weren't you forthright with all the details? That was the question.
So again, I'm going to ask you, even if this letter's from her, these pictures are from her, how does it relate to her credibility before the jury?
Who else could these pictures be from?
I'm going to ask you point blank. Did you get a letter that's signed from her?
I got. What do
you mean signed?
How do you know? Why do you have a belief that they are from her?
I have multiple letters from her.
You're not answering my question
at all.
Why do you believe the letters are from Erica Patterson?
Because they were sent from Erica Patterson. Why else would I?
Were they signed by her?
What do you mean signed?
Did she write her name on the letter? Was it the content of the letter? No, I'm not kidding you. I need to make a record, sir. You're making a statement that these letters are from her and that they're relevant to her credibility.
Your Honor, I'm going to go out on the limb here.
And I'm asking you why you hold that opinion.
I'm going to go out on the limb here and assume, which I know is true, you've never been in my position. You've never been in jail. So you've never received a letter from someone writing someone in jail.
What?
No one is going to... When you
You're
say
not
to me,
answering my
when
question,
you say to
sir.
me,
What's the
that's the stupidest shit I've ever heard. So somebody goes and they write a letter. They write a letter, and they don't end the letter. It just trails off. But there's no, well, I'll see you later. Love you, Dad. Love you, Boo. And they don't sign. I don't know. Okay. I know if I had written one of my drunk uncles that was in prison a letter, I mean, I would have signed it. I mean, I never wrote him a letter because, when you go to prison and when I'm 9 years old, I kind of forgot that you existed. So, I mean, I'm just saying. But I don't know who doesn't sign letters. When I give cards, something like that, and I sign it, me, my husband, and Paisley. Paisley even signs letters and cards. Even Paisley does. So we know this is a lie. Lies.
Basis why you believe they're from Miss Patterson. Is there some information in them that only she would know? Did she sign the letters? Is it penmanship that you recognize?
She trying to help your dusty ass. Listen, twat waffle. Quit twat waffling and listen.
Why do you believe they're from her as opposed to somebody else sending you information? Could be your mom, could be, I'm just saying, could be anybody else. You got to answer my question. It's called an offer of proof.
But you still got to understand why this is mind-boggling.
Mind-boggling.
Like how I got a child with this woman. Why would I not know her handwriting?
But that's all your bitch ass had to say. I know her handwriting. That's how I know it's from her. But you know what? You can't say that. You know why? You can't say because you're lying.
Why would I not know?
Foundation for these letters, sir. That might be through your own testimony. So that I'm trying to figure out why you believe they're from her, not all this other stuff about I'm in jail and I have a child. I'm trying to. I need to know. It's called an offer of proof.
Are you serious?
What do you believe? Why do you believe they're from her? I am serious. And
because they're from her.
But you're assuming.
Like how else am I supposed to answer that?
She gave you
I've given you a few reasons why it would lend to that opinion.
So it has to be put in a legal term.
The bottom line is I need the letter.
Yeah, yes, it's gotta be put in legal terms. You're in court, a court of law. You're the defendant representing yourself. Yes, it has to be legal terms. Yes. Like, I don't know why this is confusing to you. Yes.
I question her on that. The state absolutely has a right to see the letter. So you need to provide that letter. The bottom line is I'm not going to allow any questioning without having that letter. So the state has the ability to question you about that or question this witness and to look at the veracity of what your claims are here. So when we may take it if that's in your cell, then you can go get it and bring it. But without that letter, I'm not allowing this line of questioning.
He is so petty. I love it.
Do you have the letter with you in court?
I just said no. How many times I got to say the same thing on record?
You know, sometimes, sir, I don't hear what.
Don't you hate the way he says thing? He says thing. Everything. I hate the way he pronounces some of his words. They're just, ugh. Okay, I'm gonna be quiet.
You say because you interrupt me so much or you answer quietly. And I'm taking notes and I'm focused on probably a dozen things at the same time.
But if I say something under my breath, everybody seems to hear it. Everybody seems to hear that just fine. In a quiet courtroom,
you can hear it very clearly.
Everybody assumes that it has to be disparaging.
Once again, you're doing this tactic.
Because it's not a tactic. It's facts. It's facts.
To some other reason.
It's facts. Because I find it hard to believe that
I'm going to
all
let
of
the
a sudden nobody hears what I say.
I'm going to let the state make a record of why they believe it's objectionable because I haven't let them do that. I've given you multiple opportunities to tell me why you believe it.
I didn't get these pictures from nobody else. Why was somebody else?
The record will reflect you have two pictures that you believe were from this witness.
That I know is from.
No, that you believe.
That I know.
All right. I'll ask the state their position on all of this.
My position, Your Honor, is that these pictures, first of all, should not be admissible. One, because of a discovery violation. We've never seen them before. Two, because we have reason to believe that he did not get them from Erica Patterson. He is on a jail phone call talking to his mother, Dawn Woods, about Dawn Woods sending these photographs to him. Now,
that's a lie. I object to
Let
that.
the state make their argument without interruption, sir.
That's a lie, though.
Three, I believe that these photographs are designed to make a suggestion to the jury that Erica Patterson is a bad mom. I think that that's what the defendant is trying to do. And if we're going to go down that road, then we would be forced to counter that claim. First of all, it doesn't make her an incredible witness, if it's even true.
If it's even true.
Second of all, if we go down that road, we would be forced to counter that claim by pointing out that not only does the defendant not live with the child in question, he doesn't live with any of the other children that he has. He impregnated Erica Patterson when she was a minor in Nevada And for doing so, he was convicted of statutory sexual seduction, pled guilty in March of 2007 to that felony offense, and is a sex offender on the registry as a result. So if there's any causation that would lead to Erica Patterson being a bad mom, Mr. Brooks has a direct role in that causation.
And that's
furthermore
to that.
I'm not
because
done.
that's a lie.
Let him
Because at the end of the day,
Let
if
him
we
finish,
gonna open the door
Mr.
on that, no,
Brooks.
since he want to make a record and not be accurate, so let's be accurate all on the record. Since you think you know so much,
Once
so
again,
we can
Mr.
open the
Brooks
door
is
on.
being
We can open the door on how old she told me she was when we met.
interrupting.
We can ask that question
He is
too. Then
over the
Did you
top
ask that?
animated
Did you
right
know
now.
that?
Mr. Brooks, I'm ordering you to sit down and to let the state
No,
finish.
no, I'm not going to sit here and let somebody be inaccurate on the record and lie on the record.
Right. Under Illinois versus Allen, I've warned him repeatedly. He's being removed from the courtroom. And you know what? Let me dial that back. We're just going to take an early lunch, 1 hour. We'll be back. And unless he brings that letter,
he mad.
Show it is inadmissible. She will not be questioned. And under 906.11, I will declare the cross-examination closed. Thank you. We're in recess. 1 hour.
Get your facts straight. So let's open the door on all of it then, so we can get all of it on the record. Since you think you know so much. Did you know she said she was 18 when I met her? Did you know that?
Did you know that? Be that as it may, ho, you were 20, what, 22? You was 22. So, like I told Erica when I talked to her, you look young now. I know that you looked like a baby for real at 14, 15 years old. Like, come on, man. Since you think you know so much, let's get it all on the record then.
12:10. I do have Mr. Brooks in the other courtroom so that I could make an adequate record without interruption. Today has been a rough morning, to say the least. We are in the stage of this trial where Mr. Brooks has the right to present relevant and probative evidence and to call witnesses. And I have done my very best to honor his rights in that regard.
Shock him.
Part of this morning dealt with his, from my perspective, disagreement with how I yesterday and in the days preceding that set up what I thought was a very reasonable way for witnesses to be called into this courtroom on his behalf. Going back to when the state offered to serve subpoenas on his behalf and talk with or coordinate with these witnesses to come into court.
I know she's tired.
And yesterday, I wanted to narrow things down a bit, as is my not only right, but frankly, my obligation under 906.11 to make sure that there is an effective presentation of evidence.
Look at him.
So
he fake reading his Bible. You know he ain't reading because when he reads, his head moves. So he's just holding the Bible and not listening. She got all these boxes here that you remember. He didn't have time to go through them yet. He ain't had time to go through them. So what does he do? He reads the Bible or has the Bible for a prop. Hold on. Oh, there we go.
And exercise reasonable control over the mode and order of interrogating witnesses and presenting evidence so as to do all of the following. And let me just back up a moment, because I think it's worth putting into the record once again the full language of 906.11, which is entitled Mode and Order.
I don't care about that.
11. And of other parties in the courtroom. He repeatedly references things such as subject matter jurisdiction, which there is a written decision that I have filed in this case. It is very clear this court has subject matter jurisdiction over this case. This is not a civil case. This is not a case in federal court, for example, where subject matter jurisdiction sometimes becomes an issue for things like whether there's a federal question that's involved.
Didn't I tell y'all that?
Every now and again in a criminal case, subject matter jurisdiction is a type of issue that comes up, but not under the circumstances here.
At all.
I'm not going to rehash everything that's in my decision. I stand by that decision.
Sure did, Toby.
The record has been made abundantly clear that Mr. Brooks does not believe this court has jurisdiction. His objections have been noted, well documented.
And nobody
by the record
cares.
that's being taken down. I know from my experience, not only as a judge, but as a litigator, that once that objection is made, it's preserved. I even stated at one point, I think there's a standing objection. I will note that for the record. Mr. Brooks continues, in my opinion, to bring this issue up in front of the jury to distract, to delay, and to call into question the integrity of these proceedings. Frankly, maybe to create an issue on appeal. If
Yes.
he is convicted.
And he will
I
be.
brought him, I should state it this way. He is not in this courtroom presently. And specifically this morning, right, we have a history of disruptions, delay, interruptions, disrespectful behavior, the common courtesy, I think that just as a human being, we all would expect, have not been followed. It's evidently made, let me restate that. It is evident to this court that when there is a ruling that Mr. Brooks disagrees with, whether it be an evidentiary ruling, whether it be on subject matter jurisdiction, whatever it may be, that he has a pattern now of directly confronting the court, asking for, is that verified law? Can you prove that? Is that an actual law? He starts debating the topic once again, or he will even try to further turn us away from that by bringing up another topic. For example, just today, when the issue came up about this letter that he claims was sent to him by Erica Patterson, and I asked repeatedly for an offer of proof rather than answer the question directly, Mr. Brooks instead started talking about an exhibit the state offered into evidence yesterday. And from my perspective, he doesn't address the merits of the issues that are before this court and then tries to divert things down a different path, whether that's to delay, to disrupt, or just simply be discourteous. I think all of those words would be an accurate description of what is happening. That was one piece of, or one objection or series of objections that I actually went off the record. Not off the record. I actually dismissed
Page has not turned.
in order to try to get an offer of proof from Mr. Brooks. And as that exchange went on, it got, from my perspective, he got louder.
Yep.
He got more disrespectful.
Yep.
I think it's fair to say his behavior was volatile, and it's because of that that I called an early lunch.
He's a liar.
And it's because of all of those things. Even when I attempt to give the warning that he will be removed upon further behavior, he immediately interrupts.
Yep.
And says, "Are you holding me in contempt?" A very clear indication to this court that he is attempting and trying and actually disrupting the proceedings so that I can't make an accurate record. Like I said, it's challenging. That is why he is in the other courtroom muted so that I can make the record. And I will confirm with my clerk and the bailiffs. I should have done this at the beginning, but I believe, thank you, my clerk did confirm that they can see, they can hear, we can see as well. It is this court's opinion that Mr. Brooks is blatantly pushing the limits of what I have tried to establish in terms of when to call witnesses, how to call witnesses. He pushes the limits on asking questions that are not probative, that are not relevant, or that directly contravene a prior ruling by this court related to other acts evidence. That ruling that I made was to the benefit of Darrell Brooks, not the state, Darrell Brooks, the defendant. There have been multiple witnesses who have themselves basically looked at me and can I answer that question? Basically, is there nonverbal communication to me? Or some have actually said, I don't think I can answer that. There have been other witnesses where I've stopped them from answering so as not to bring in the other act's evidence. The most recent of which occurred this morning with Erica Patterson and the repeated questions to her related to either information she did or didn't give the detective when the detective spoke to her on two separate occasions. There's been other questions throughout the trial to, I believe, to Detective Guth directly and other witnesses who had information about why that may have been the case. But this witness,
please smash that
just
like
be
button.
Very, very careful to not run afoul of the court's prior ruling. That leads to the evidence claimed by Mr. Brooks that he has related to a letter and photographs. As I indicated before the break, I've looked at both 906-16 and 906-08. Those are generally two of the statutes dealing with character evidence. That would be 906-08, 906-16 deals with bias. From my perspective, the questions that were actually asked and answered about do we have a child together? Well, he didn't ask it quite that way. I'm summarizing, but regarding their common child, regarding whether he sees the child on or off, where they met, things of that nature, are solely to attack her character, as a mother, which is wholly improper. The only character evidence that would remotely be allowed under, at least for a witness under these circumstances, would be character for truthfulness, which would not even be from this witness. It's typically another witness comes in and testifies to that, and only about opinion evidence, their opinion of the person's character for truthfulness. Under bias, 906-16, I didn't see where it also related to her credibility. It says, for the purpose of attacking the credibility of a witness, evidence of bias, prejudice, or interest of the witness for or against any party to the case is admissible. Again, simply attacking.
Okay. So before I leave, I was thinking about, I was going to play him doing that Babiasz chick at the end. Yeah. Her, Katrina Babiasz. Look at this doofus.
Defense calls Catrice. I don't know how to say the last name.
Can you give me the...
Now, you see this? He's got his Bible here for some reason, but not a procedure and statutes book. This is stupid jailhouse Bible.
Spelling that you have?
Babiasz.
Thank you, ma'am. Please have a seat. First thing I will ask you to do is to state your first and last names for the record, and then spell each.
Catrice Babiasz, Katrice Babiasz.
Thank you. My apologies for mispronouncing that earlier. Go ahead, your witness.
Good afternoon, Miss Babiasz.
Correct.
I'm surprised I got it right. What do you do for a living?
I am a law enforcement dispatch supervisor.
How long have you been doing that?
Okay, so I'm sorry, I didn't just interrupt this. So she's a law enforcement dispatch. That means she is not an actual police officer or a fed. She's not one of the alphabet boys. She's a dispatch supervisor. I just wanted to just throw that out there. Let's continue.
I've been in law enforcement for 16 years.
The evening of November 21st, 2021, were you on duty that evening?
I was not.
What were you doing that evening?
I was attending the Waukesha Christmas parade with my family.
And do you recall what time you arrived there with your family that evening?
I arrived to the parade shortly after it started, so it was right after 4 p.m.
And do you recall where you were positioned at with your family when you arrived at the parade that evening?
Does it freaking matter?
And where were you positioned at?
I was towards the beginning of the parade. I was on Main Street where it connects with White Rock Avenue.
Did anything catch your eye that evening when you were positioned watching the parade with your family?
What a dumbass question to ask. What a stupid question to ask. Did anything catch your eye when you were there with your family? Yeah, you caught my eye driving a red SUV, plowing into people.
Yes.
What did you see?
I saw a red SUV coming from White Rock Avenue. The vehicle caught my attention because people started yelling, and the driver was honking the horn.
And
that's the only reason she got called, was because in her summary of her statement that she gave to the police is that she honked, she heard the horn honk. That's the only reason. He didn't read no further than that.
Do you recall, to the best of your knowledge, it's been a little bit, the driver of the vehicle you observed was honking his horn, was it gesturing to people?
Yes.
Vehicle.
And what do you see? What did you see the gesturing as?
I'm sorry, I don't understand the question.
It don't make sense.
What was the gesturing?
What was the driver gesturing?
Yes. I'm sorry.
It's okay.
Yeah, he's sorry. He's stupid.
Taking his hand and going like this, really rapidly, aggressively.
You yourself being in law enforcement and just based on what you were observing, the driver of the vehicle you observed was honking his horn and gesturing with this motion. Would you take that motion as trying to alert people to move out of the way? Grounds.
Sustain us to the form of the question. Please rephrase.
How did you yourself take that gesturing?
I took that gesturing as the driver was telling people to get out of his way.
Did the vehicle pass pretty close to where you were positioned?
Yes, the vehicle almost struck my daughter.
Uh-oh.
Do you recall seeing the driver?
I looked the driver right in the eyes.
Uh-oh.
And how did the driver look?
The driver looked like through me.
Ooh.
What do you mean through you? Describe what you mean by through you.
I feel that it is very hard to explain that look. But it was very frightening.
Do you recall what the driver was wearing?
The driver had a hoodie sweatshirt on, and something on his head. I wasn't sure if it was the hood of the sweater or maybe a beanie hat. It was winter. I'm not 100% sure.
Were you able to see any hair?
I did see hair, yes.
How would you describe the hair?
The hair on the head was in front, like dreads down here from what I could see underneath the hood or the hat. And then there was facial hair.
Somebody in my comments said that Erica said that those dreads that he had were extensions. Those shit locks were extensions. I don't know if anybody can verify that, if that's the truth or not. But that's real gangster.
Beard and mustache.
When you observed the vehicle approaching, was the vehicle speeding?
When the vehicle was approaching from White Rock, the vehicle was not speeding at that time.
To the best of your knowledge, do you recall there being any barriers present where you were positioned at?
Yes.
Do you recall if the vehicle you observed had any tinted windows?
Oh, thank you, Dustin.
I do not recall.
Were you able to make out a license plate number of the vehicle, being that it had passed so closely by you?
What the hell is a license plate? A licensed place. What is a licensed place? Now, is that the licensed place? You know, the DMV. Is that what you mean by licensed place? Surely you don't mean a license plate, do you? Do you?
No, once the vehicle continued past my position, I was more concerned about my children that were with me.
I'm assuming at some point you spoke with the law enforcement about what you saw that evening. Would that be fair to say?
Yes,
And do you recall what agency that was?
I do.
And what agency was that?
The FBI.
Them alphabet boys.
At what point were you not able to see the SUV once it passed you?
I lost sight of the SUV once it went into a bunch of people.
Oh, well.
Do you recall what date it was that you spoke with the FBI agents on? Was that the same evening or a few days after?
It was not the same evening of the parade, but it was that week. It was within the next few days.
The day you spoke with FBI agents, do you recall stating the driver was wearing a red top that appeared to be made out of a sweatshirt-like material?
I don't recall exactly what was said to the agent, but I do remember the sweatshirt, yes.
A red sweatshirt?
It's possible.
Just a little bit ago, you said that, well, when asked the question of did you recall hair for the driver, you stated and made the gesture that the hair was in front. Do you recall saying that?
Yes, sir.
Do you recall when speaking with FBI agents stating that the hair was pulled back?
The hair appeared to be like possibly in a ponytail, but it was so full that it was coming forward.
Do you recall, well, let me back up. Did you leave the parade at that point?
At what point?
After seeing the vehicle?
Yes.
Were you injured the evening of the incident?
Uh-oh.
Yes.
Uh-oh.
You were injured?
Yes, I was.
Uh-oh.
Any reason why that's not reported?
Probably because I didn't tell anyone else.
Uh-oh.
If you were injured, why not tell anyone?
Because I haven't wanted to talk about the traumatic experience that I went through for still reliving the weeks and days after the incident.
It doesn't make any sense. You talked to FBI agents the few days where you said you didn't, to be fair, you said you didn't know. You said it was that week is what you said. The same week.
A license place.
You spoke with FBI agents, reported no injuries.
They didn't ask me about injuries.
Well, would it be fair to say that kind of information would come up when talking to law enforcement, seeing as how you yourself work in law enforcement?
No.
It just seems odd, don't you think?
I do not. I was not physically injured.
Oh.
But you didn't report this at any time whatsoever. Grounds.
Sustained.
Substain.
Already answered.
So did you speak to anyone about this in law enforcement?
Objection made.
Grounds.
Overruled. She may answer. He clarified law enforcement. Did she speak to anyone about this in law enforcement? I interpreted this as the injury.
Right.
So go ahead.
I feel like, no, I did not.
Did you file any claims related to this?
Oh, God, the sovereign
No, I did
citizen shit.
So is today your first time bringing up your alleged injury?
Oh, a lid.
No, it is not.
At some point, you were subpoenaed by the district attorney's office to testify here to testify in this trial. Would that be fair to say?
Oh, here it comes.
Yes, it is.
Here it comes.
Do you recall when you received that subpoena?
From the district attorney's office, it was in July.
And do you recall whom you spoke with about the information regarding the subpoena?
I contacted the victim witness advocate, Carrie Peterson.
You contacted the Ms. Peterson after receiving the subpoena?
Correct. The instructions told me to.
Okay. You ever spoke with anyone directly at the district attorney's office?
No, correction. Yes, when I walked in today, I met there and let them know I was here. And then they walked me into a room and I waited until I was called.
So before today, you had no interactions with anyone related to the district attorney besides I think you said victim advocate?
So the victim advocates who have been in connection with and letting me know when to come and all of that.
Of the three district attorneys seated to my left at this table, had you had any interactions of any kind with any of those three district attorneys?
I have not.
Uh-oh.
I believe, just for the record, when you asked that, Attorney Basie was just pointing to herself and the two people next to her. So it's clear.
Here it comes. Here it
Since
comes.
there's two tables.
What would be the reason for that?
Since there's two tables of individuals, I think she wanted to make the witness aware. And I just wanted to point it out. For the
So this was proof. It was proof that it was a conspiracy, a conspiracy. And he like his brain. Well, the technical brain, you know, the one that operates his body, not an intellectual brain. But the wheels are spinning because he's like, oh, I didn't figure this one out. Because, you know, he been dropping jewels all day, you know, just throwing it out, dropping mics all day. So he done caught another one.
Working in law enforcement for 16 years, I'm sure this isn't your first time being involved in a trial. Would that be fair to say?
Would that be fair to
I
say?
have not been in a trial for law enforcement. No, I have not.
You've never witnessed a trial, sat at a trial, been in a trial?
Uh-oh. So remember how I told y'all that she said that she was working in dispatch? Why would she be going to trial working in dispatch? Dummy. You big dummy.
Have you ever testified in any way before today? Rounds.
Overruled, you may answer.
Douche nozzle.
I have testified before, yes.
So it would be fair to say that you would have knowledge of where an alleged defendant and the district attorney would sit in the courtroom, correct?
I know where they're sitting, yes.
Oh, he mad.
I want to back up a little bit to
back that ass
the
up.
observation of the vehicle the evening of November 21st, 2021. While you observed the vehicle approaching your position, did you see it strike anyone?
I did not see the vehicle strike anyone, no.
From your opinion, observing the vehicle approaching your position, did it appear that the vehicle attempted to strike anyone?
Yes.
Dumbass.
And why would you come to that conclusion?
Because I saw an officer have to jump out of the way in order for
when it was approaching.
I'm confused.
Hold on, everyone. The question was asked. This witness is going to be allowed to answer the question fully without interruption. Go ahead and answer the question.
Thank you. I misunderstood his question, I guess.
Answer the question that as you understood it.
Yep. So I saw that an officer have to get out of the way. And he was attempting to stop Mr. Brooks from driving through the parade. And he was at the last minute jumped out of the way from the vehicle. Otherwise, he would have been struck.
Move, bitch.
You
get
just
out
used
the way.
Mr. Brooks, for the first time that you've been testifying. Ooh. Would that be fair to say?
I don't understand your question.
You just used the name, Mr. Brooks, for the first time since you've been testifying. Is that fair to say?
That's fair to say.
Man,
Yes.
him man.
Why haven't you used that name before? You've been up there for quite some time.
I didn't need to.
So what changed for the last question that you needed to?
I don't understand your question.
You just stated that you didn't mention the name before because you didn't need to. So what about the last question that you answered made you feel like you needed to use the name for that question and no question before that?
I don't know.
Out of curiosity, how did you come to the knowledge of that name?
It was on the subpoena I received last week.
You just stated a little bit earlier in your testimony that you received your subpoena in July. Now you said last week.
Those are both correct.
Dumbass. Oh,
So
thank
you
you, Trish.
received two separate subpoenas?
Correct.
Yes, fool. Yes.
What was the difference between the two?
Idiot.
One was from the district attorney's office and one was from you.
So the one that you received from the district attorney's office in July didn't have a case caption on it?
Bitch, you've just learned what a case caption is. And so now you're going to try and use that against her. And did it come with a case caption? Yeah, it came with a case caption. Stupid. Stupid.
Okay, what's a case caption?
And then, okay, and then he goes, oh, let me just say, he going and shuffling papers, trying to find something with a case caption on it. Everything you got a case caption on it, nutball. He makes me so sick. I freaking hate him. Yeah, thank you, Trish, for joining us. Thank you, thank you.
Just 1 second.
Thank you,
1
Bex.
second, Your Honor.
I really don't know what the relevance is for
It ain't now.
purpose of this trial.
There was no objection at first.
There's no.
I'm going to sustain the objection under 906-11. I don't believe it advances
906-11.
I think
the trial.
I think you know where I was getting at with the question.
Nobody knows where you're going.
Then you need to ask your question directly, sir. Go ahead. But I'm sustaining it as to the form of the question.
When you were subpoenaed in July by the district attorney's office, the subpoena didn't contain information to the case you were being subpoenaed for?
Objection to relevance.
Grounds.
Sustained. You don't have to answer that. I sustained the objection on that. Those grounds. Ask the question I believe that you're trying to ask, not that one.
Was the name that you mentioned,
Oh,
Mr. Brooks, anywhere on the subpoena that you received from the district attorney's office in July?
so you know he mad. You know he mad when he starts beating that pen across the table, like he did that with the detective that had the video. He opened the door and had the video played, and he was like, "How did this video become an exhibit?" So you know he mad when he started beating the table with his pen.
Objection, relevance.
Grounds.
Oh, sustained.
Grounds for the sustained. That
Not
was,
relevant.
Substain. What? Mind-boggling. Mind-boggling.
In July, when you received your subpoena from the district attorney's office, were you even aware what you were being subpoenaed for?
Objection, relevance.
Grounds.
Sustained.
Well, Jason, you know what? When he finally said tacit, I was like, oh, somebody must have helped him. Somebody must have told him tacit is not a word. It's a tacit agreement.
Not relevant.
She's testifying in the trial, and it's not relevant that she got subpoenaed?
Mr. Brooks, she's here under your subpoena.
What?
You called her as a witness. It's
The
your
subpoena is relevant because she
Mr.
was
Brooks,
already
under
subpoenaed.
906-11, please ask the witness a
This is
relevant and
It's
appropriate
mind-boggling.
question.
This is mind-boggling.
Mind-boggling. Mind-boggling.
Remind the jury that the statements of the parties or the attorneys are not evidence.
Oh yeah, he mad now.
So heard that it was a chance you would be possibly testifying in this trial?
Yes.
And did you know who the trial was for?
Objection.
Grounds.
Grounds.
Sustained.
Grounds for sustained.
It's not relevant.
I've never heard of nobody testifying in a trial that they didn't know who the trial was for.
Mr. Brooks,
I think
I'm
that's very
sustaining the
relevant.
objection under 906.11, and I'm asking you to move on.
Y'all, it's ridiculous, man.
906
Seems to me
11.
like a like a lot of your answers are coached. Is that fair to say?
No.
They laughing. Oh Lord.
So the subpoena that you got last week, is that how you learned the name that you used?
Objection.
Grounds.
Relevance for the same reason I argued.
Grounds.
Asked and answered. She's indicated the answer already. 906.11, sir. Next question.
The question
Different
was,
topic.
is that the first time that she saw the name?
It's not relevant.
That
Next
was not
question.
asked and answered. That was not asked nor answered.
Not asked nor
906.11,
answered.
please ask a question, sir.
Man, what is y'all people trying to pull up, man? This is
And he's doing this in
Mr.
front
Brooks,
of
if you don't ask
the
another question
jury.
that's relevant and probative under 906.11, then I will turn the witness over to the state for
Woo!
their cross-examination.
and then I should be able to get redirect, right? Your Honor.
Ask a question, or I will declare the examination by you to be ended.
It's not an examination, it's direct.
It's a
He's gonna try to correct the judge. It's not an examination, it's a direct. You've been in court from all across the country. You've been to court. You should know direct examination and cross examination. Like, dude, are you serious?
the direct examination, sir. Under 906.11, you are directed to ask a question, or I will
I
ask
heard,
the
I heard
state
you.
if they
I
have
heard
any
you, Your Honor.
questions.
I heard you.
Woo, look at him. He mad. Oh, he mad.
I heard you.
Thank you.
Ooh, look at him. Look at him. If he had an SUV, he would drive it right into her.
Next question, please.
You know who the plaintiff is in this matter?
Yes.
Who's the plaintiff?
The state of Wisconsin.
Is that an entity or a living human being?
Objection.
Grounds.
Not relevant, sustained. Next question.
Have you ever had any interaction with the plaintiff?
Objection. Vague.
Sustained.
Vague.
As to the form of the
Have
question,
you ever had any interaction with the state of Wisconsin?
do not answer that question. Next question, sir. Under 906.11.
Was there an objection or was that just a ruling? I'm not sure. You're both was talking at the same time.
Under 906.11, I directed the witness not to answer that irrelevant question. Ask your next question, sir.
Come on, twat waddle. I'm gonna use that one, twat waddle. He is petty on 10. That's why I like his videos.
Ask your next question.
I'm gonna get to it.
Woo.
Thank you.
Yes, you saw he had the little his nostrils flared at her. Oh, child.
So when did you first report your alleged injury?
You do not have to answer that question. Next question, sir.
Grounds for
906.11.
906.11.
Sub 1, sub A, sub B,
and
sub
sub C.
Is that lawful law?
All right. You may sit down. Does the state have any questions for this witness?
Oh, God. They look like, should we?
Ma'am, that day on November 21st of last year, you were there with 2 kids?
I was, yes.
What were their ages on that date?
Objection.
3
relevancy.
and
Overrule, the witness may answer.
Of course, it's gonna be overruled.
3 and 6.
And I don't know, Mr. Brooks can sit down. I'm kind of asking the questions right now.
Mr. Brooks, please sit down. Mr. Brooks, you're not asking the questions.
I'm not saying
I would
anything.
ask you to sit down, please. It is disrespectful to this witness and to the state and to the court.
No, it's not. Not doing anything wrong. I'm merely standing here.
And when you were at the parade on November 21st of last year, approximately where were you watching the parade from?
Asked and answered objection.
Mr. Brooks, it's cross-examination. Just because you asked the question initially and she answered does not mean the state doesn't get to follow up on it.
So the state can ask the same question I asked.
The state can ask that question.
So how
Go
come when
ahead.
I did that,
Overrule,
it was
the witness may answer.
sustained?
I was on Main Street, but right by where the intersection of White Rock, and I was in the roadway.
I'm going to show you what's been marked and previously admitted into evidence as State's Exhibit 15.
Go ahead.
And I ask that the screen be cleared. Ma'am, do you see a purple line that would indicate the parade route going from White Rock Avenue down Main Street?
Yes, I do.
And can you approximate where you and your kids were watching the parade? Okay, thank you. Would be fair to say is to your left would have been Pleasant Street?
That is correct.
Were there barricades blocking Pleasant Street?
There were
Objection, asked and answered.
Overrule, the witness may answer.
There were barricades that were partially black. They were on Main Street, but partially blocking Pleasant Street as well.
Could a car have gone down Pleasant Street?
Yes.
Objection.
Overrule, the
Hearsay.
witness may answer. It's not hearsay.
So when the red
Hearsay.
SUV came down White Rock Avenue and was making its turn onto East Main Street, as you testified, it could have just gone straight onto Pleasant Street, correct?
That is
Objection.
correct.
It's hearsay. She's speaking as
Hold
first
on.
eyewitness,
There's an
first-hand
objection.
eyewitness.
It's not
Mr.
hearsay.
Brooks, your objection is noted. It's overruled. The witness
As
may
usual.
answer.
It's always overruled.
Go ahead, you may answer.
Sorry, there's a lot of talking. Your question was, just to clarify, could the vehicle have gone straight onto Pleasant Street? Is that right?
Yes,
Okay, yes.
thank you. And where you stated that you and your kids were partially in the roadway when the red SUV came through?
Yes, we were.
Objection. That's mischaracterization of what was testified to.
Overruled, the witness may answer. Go ahead.
Give me an answer.
Can you repeat it?
Sure. Were you and your kids all in the roadway when the red SUV went through?
He about to blow.
Yes, we were.
Okay. You weren't part of the parade, correct?
We were not.
Okay. So were you standing with other people that were in the roadway?
Yes, we were.
And was one of your kids going to get candy when the red SUV came through?
Yes, my
Objection.
daughter.
Speaking as a first-hand eyewitness.
Because she is a first-hand eyewitness.
No, I'm talking about you.
Objection is noted. It's overruled. The question is proper and the witness may answer.
Yes, my daughter was further in the roadway. We were all in the road, but she was further in the roadway, reaching to grab candy.
At any other time, you stated that this was towards the end of the parade. Is that correct?
Yeah, we saw Santa, and he's always like the end of the parade.
And had your daughter gone to get candy at other times?
The entire time.
Had she, during the time preceding the red SUV coming through, had she almost been struck by any other participants in the parade?
No, she was nowhere near like where the vehicles were driving through the parade. She was, no.
So she's going out to get some candy that had been thrown, I assume, correct?
Yes.
And
Overruled, the witness's answer may stand.
you see this red SUV coming. Is it coming from your right or from your left?
The red SUV was coming from my right side, which was White Rock.
Okay. And how close did it come to your daughter?
It was, I wouldn't be able to give an accurate, very, very close.
Had you not pulled your daughter away, would that car have hit your daughter?
It's actually speculative.
It's very possible.
So you say that you saw a police officer have some contact with the red SUV. Do you recall that?
Yes.
Can you describe that for the jury?
Well, there was a few times that police officers attempted to stop the red SUV. The first one would have been where we were on Main and White Rock. And then there were also other people trying to stop it too. And then again, as it drove, once it turned onto Main, the next road, I believe is Buckley. And there was another officer who tried to stop that red SUV again.
And which is the officer who had to step out of the way in order to not get hit by the red SUV?
What was the question?
Where was the officer located who had to step out of the way to avoid being struck by the red SUV?
I believe that was the officer around Buckley and Maine.
And ma'am, as the car passed your location, did it increase its speed?
Yes.
Do you know where in the roadway it traveled down?
Overruled, the witness may answer.
The direction of travel?
Where in the road? Was it on the left-hand side, the
Objection.
right-hand side, or in the middle?
It was all
Mr.
over the road.
McMahon.
You saw it all over the road?
Yes.
So going, and why don't you describe for the jury what you saw?
Driving the vehicle, once it turned onto Main, it
Don't this court reporter have some shiny hair? I just amazed. It's so shiny.
drove side to side, and then I lost sight when there were through the people as it got down the hill.
Nothing further.
Thank you. Let me read the rest.
Oh boy.
You said you observed multiple officers try to stop the vehicle. Is that correct?
Yes.
You described one that I think you said it was Buckley, right?
Yes.
Why didn't you report the other officers that you allegedly saw attempt to stop the vehicle?
I don't know what you're asking.
Report that the interview that was conducted with the FBI. That was who did your interview, correct?
Yes.
Why is it not in the report about the multiple officers that you say you saw attempted to stop the vehicle?
What a dumbass question. How is she responsible for what somebody else wrote? Idiot.
I don't know why that wasn't put in the report.
Do you recall if you told the FBI agents?
It's been a year. I believe so, but it's been a year.
When you say it's been a year, I'm assuming that means that there's some details you don't quite recall all the way. Would that be fair to say?
Yes.
So it would be fair to say that if there's details you don't recall,
Here it comes.
how can you recall half the travel of the SUV that you saw?
Can you rephrase the question? I'm not understanding.
I think it was clear.
Oh.
But I'll ask you.
Okay, go ahead. Dismiss her.
You just acknowledged that there may be some details that you don't quite recall. So would it be fair to say that you don't quite recall the path of travel of the vehicle?
No, that is not correct.
Judging by what you just stated, wouldn't it be fair to say that that's a possibility?
No.
No.
So you recall all the details of what you observed that evening, November 21st, 2021?
No.
So what other details do you not recall?
You're under, how does someone recall the details that they don't recall?
Yeah, that's what I want.
Sustained is to the form of the question.
Seems very funny.
It is funny.
Seems almost as if you're recalling what you want to recall and purposely not.
Objection, badgering the witness.
Yes, sustained. You do not have to answer that, and you are warned. You may not badger or argue with this witness. Next question.
Badger or argue.
What do you mean?
Next question.
What do you mean?
Ooh.
Don't intimidate the witness is what I mean.
How am I intimidating the witness?
Badgering the witness by eye rolling, by pursing your lips, by making facial movements regarding her
Does she
answers
feel intimidated?
is
Probably
badgering the witness.
Are you kidding me?
Under 90611,
You really
please
can't-
ask
you really
your
can't be
next
serious.
question.
You can't-
Come on, you're a little black guy, and you had on a hoodie, and you had dreadlocks. You scary. Isn't that what you want? You want to intimidate and scare people? Isn't that what you want to do? You want to be scary. Well, now you're being scary.
Can't be
Enjoy
serious
it.
right now.
Embrace it.
Intimidating the witness. What have I done to intimidate the witness?
The last question was badgering, which is a form can
But you
be.
said
Mr. Brooks, I
intimidate.
made my ruling under 90611.
specifically said
Please
intimidate.
ask a question or
I'm trying
I will
to merely-
stop the
How
questioning.
did I intimidate?
Under 90611, sub 1, sub A, sub B, and sub C, ask your next question or the questioning of this
How are
witness
you
will
even a
end.
judge? How are you even a judge?
All right, you may step down, ma'am. Thank you.
How are you even a judge? Come on, man. This must be all about the 62 trust, right? That you want to be the beneficiary of.
That's
I'm
some
going
sovereign
to
citizen
give
nonsense.
the closing instruction. We are done with testimony for today. I'll have the jurors report on Monday at 9 a.m. Thank you. You are excused. Please rise for the jury.
You don't call yourself a judge as much as bias you put up in here. Don't even tell the jury the truth. Got no integrity whatsoever. None.
Well, here's my question. He's had his mask off this entire time, and then he puts the mask back on after he's been sitting in the courtroom all day with it off. I don't understand what's this fixation with this nasty, raggedy, crusty, dusty mask.
None.
Woo!
Thank you, everyone. Please be seated. I would like an update on whether Mr. Brooks.
Oh, he doing what you do when you're a little kid. You know, your mom tells you go in your room, or she made you mad, and then you go in your room and you start talking back. I don't care what you say. Like, damn you. And she comes back, what did you say? Nothing. That's what he's doing. Nothing.
Filled out a subpoena for Dawn Woods and provided that to the state. Has that been done?
No, we haven't received anything, Your Honor, and obviously she can appear here voluntarily if Mr. Brooks wants to arrange that subpoena is necessary. We had subpoenaed her and she was under state subpoena. So I know that at least some point she had notice, but our position would be, Your Honor, that we will not be responsible in any fashion for producing Miss Woods. Mr. Brooks talks to her on a daily basis. If he wants her here, he can produce her on Monday.
Yeah, they ain't got to worry about that.
So I just wanted to know, because I know a subpoena form was filled out.
If
So
I want her to be here, she gonna be here.
I agree with
So
the
just
state
just
that
know that.
she could certainly appear.
It ain't even got to be no arrangement. All I got to say is come. She gonna come.
No.
That simple.
Mr. Brooks, do you intend to call her as a witness? Because I'm directing you
We
to have her
we
here
said
at
all-
9
We said
a.m.
all that at the beginning, man. Like, I don't even want to be in here that much longer. Just do what you got to do so get up out of here. I'm tired of being in the courtroom that has no integrity whatsoever. How can you even call yourself
Mr.
a judge?
Brooks, I need to make a record of
I need to make a record too.
You don't.
When am I going to get the chance to do that?
All right. I need to make a record. He's being removed to the other courtroom. He is yelling at me. He's not going to let me make a statement or make the record that I need to make. He hasn't sat down for the better part of 2 hours.
All you want. You can hold me in contempt all you want.
I'm not holding you in contempt.
If it's criminal or civil, so I can hit you with you.
I need to clear the courtroom because I do need to make.
Give you what you know is coming.
I need him to go to the other courtroom because I do need to put some things on the record. The record should reflect
the contract between you and I?
Mr. Brooks
is
criminal, yelling at me.
What is the crime?
He is.
Who makes the claim? And what is?
I will make the record when you get back. I will step off. But Mr. Brooks, you're being taken to the next courtroom.
Mr. Brooks, don't try to address me like that, like we cool. You don't have no integrity. How can you even call yourself a judge? Making tacit agreements, being biased, judicial misconduct, trying to steal somebody's. I know I'm muted, so.
Ooh.
Okay, that's fine. Just need to know.
Let me see. You should be muted, ho.
We don't need a clerk per se. We just need to know that the individual.
It is.
Oh yeah, he just stands there and reads his Bible.
Am I muted?
To reflect that Mr. Brooks is in the adjacent courtroom. I have verified the audio and video are working appropriately. I need to address some scheduling issues, but before I do that, I need to make a record that at the very end of, after I read the closing instructions, Mr. Brooks started to make disparaging remarks about the court in the presence of the jury. I did not respond to those. And once that jury left, he got incredibly loud. He was yelling at me. He, I think, had been standing for the better part of the last couple of hours, even though at one point I directed him to sit down after the direct examination of the last witness. It was apparent to me that he was not pleased with some of the rulings that I had been making regarding objections. I would just remind him that this was a witness he called. Therefore, it's proper and allowable under the law, under 906.11, sub 3 to be exact, for the state to ask leading questions, which
because it's cross. It's cross.
And at the very end of that, there was an objection based on badgering, which, as the record reflects, I sustained. His voice got louder. He continued to stand. He was being very argumentative with that witness, who, again, he called. Given his posture, given his staring, given his pursing of his lips, given the way that he kept asking the same question in different ways, but over and over, not satisfied with the responses that had been given or the court sustaining the objections, that is why I made a finding at that time and sustained the objection for badgering Mr. Brooks, who asked me what that meant. And I indicated it's a form of intimidating a witness. I don't mean that in the sense of there's a charge of intimidating a witness. That's not certainly what I meant, but really in the common everyday usage, it's another word. It's a synonym for badgering. Clearly, he was displeased with the court. After that, I cut off the examination, which I had given a number of warnings that I would do if he didn't ask an appropriate, a probative, a relevant question. During that time, frankly, even during his direct examination, definitely during the state's cross-examination and then redirect, it was very apparent to this court, and I think to anyone who was watching, that Mr. Brooks was not pleased with the witness's answers and would roll his eyes at her, or just to himself, I guess, and purse his lips and make other gestures that it was apparent to this court, he did not like her testimony. And again, I'd remind everyone that it was his witness, and he had the police reports for this witness, and obviously was fully aware of her statements to the investigators in this case. So I just wanted to make a record of that. It's in part why at the very end, and given the history of today and his conduct and being removed previously, I thought it important that the court remove him at the end of the hearing outside the presence of the jury so that I could get through a couple of things. We have gotten through the witnesses for which Mr. Brooks issued subpoenas that the state assisted with. I did provide permission to him earlier today, if he so chooses, to call Dawn Woods as a witness. The only other witness at this point that I can identify that's been for which the court and the state has been put on notice, of course, would be Mr. Brooks himself. I'm not looking for an answer today, but what I wanted to put on the record and what I will put on the record are certain advisements that he can certainly contemplate over the weekend so that when I do the colloquy with him on Monday morning, he's had a sufficient opportunity to think about his decision to testify or not to testify. The advisements that I will give Mr. Brooks at the moment are as follows. Mr. Brooks has a constitutional right to testify. If he chooses to testify, I'm further advising him that the state has the right to ask questions of him, what is referred to as cross-examination. That may include reference to whether he's been convicted of crimes in the past. I still need to make a ruling on that, and I will do that first thing Monday morning. I will also advise him that he has a constitutional right not to testify, and that a decision not to testify, that a jury will be so instructed, not for that, they will be instructed that that cannot be used against him in any way, and there's an appropriate jury instruction on that. If he chooses to testify, the other jury instruction that is typically read simply advises the jury to assess credibility no differently than how they would assess the credibility of any other witness. There's the added paragraph to jury instruction 300. I would further advise him that it is his decision and his decision alone on whether to testify. I will ask him whether anyone has made any threats to influence his decision on whether or not to testify. I will ask him whether anyone has made any promises to him to influence his decision to testify. I will rely upon upon the record, specifically the record made during the waiver of attorney regarding his education. I will ask him whether he's had any medication, alcohol, or drugs within the last 24 hours prior to the colloquy. And I may also confirm that he's able to read, write English. Again, I may also refer back to the colloquy I had during the waiver of attorney hearings. I will then ask him whether he's made a decision, and then ask what that decision is. And then based upon his decision, I, of course, will make an appropriate finding.
None of this is going to happen.
Given how this trial has progressed and the disruptions and some of the issues with, consent or lack of consent, or that Mr. Brooks sometimes raises, I'm also going to today that failure to answer the question on what is your decision, a failure to answer, this court will interpret as a no, meaning he will be choosing not to testify, and the jury will be so instructed. And I may ask that question more than once, depending on the circumstances. I'm also going to direct the parties to some cases that I think may become relevant about potential testimony, the scope of it, Chambers versus Mississippi. It's a U.S. Supreme Court case from 1973, found at 410 U.S. 284. Rock versus Arkansas, also a U.S. Supreme Court case, 483 U.S. 44. State versus Anthony, which is a Wisconsin case, 2015 Wisconsin 20. These cases, of course, recognize that a defendant in a criminal case has a fundamental constitutional right to testify in his or her own defense. Of course, that right stems from various constitutional provisions, including the 14th Amendment, which protects the defendant's due process rights to be heard and offer testimony, the 6th Amendment, which protects a defendant's right to call witnesses in their favor, and the 5th Amendment, which protects a defendant's right against compelled testimony unless he chooses to speak on his or her own behalf. I'd also point the parties to State versus McDowell, 2004, Wisconsin 70. Although the right to testify is a fundamental constitutional right grounded in personal autonomy, it is not absolute. There is no constitutional right to present irrelevant evidence. State versus Robinson, 146, Wisconsin 2nd, 315. Moreover, a criminal defendant's right to present relevant testimony is subject to reasonable restrictions. Citing to Rock versus Arkansas, there's a balancing test that if and when this court is faced with any of these situations that I will be prepared to go through. Of course, Illinois versus.
Yeah.
So with that caveat, but the preliminary instructions were 69 pages with the 14.
Yeah.
For the testimony of two different witnesses, we provided Mr.
I don't think he says anything else. Oh, there you go.
Sir, anything you wish to address before we break for the day?
Yeah, I can. I wasn't really hearing everything that was just said good. But why haven't I been given the chance to offer all my filings and the evidence when I already stated that before? I would like all my filings. I would like every single filing that I filed placed into evidence. Every last one of them. That has yet to be done. I put you on notice and I on the record. Even before I even had a chance to start calling witnesses and put on a defense that I haven't even been adequately been able to do.
Because you're an idiot.
So this is something that's been stated on the record numerous times. I did hear a reference to whatever he was just talking about. Whatever he was just talking about is
whatever
in regards to me going to get the letter or whatever the case may be. First of all, it's not just one letter. Like I stated before, it's multiple letters.
Oh, multiple letters.
And for somebody that don't even know to try to tell me what I got, like you need to cut it out, man.
Yeah, cut it out, bro.
You need to cut it out. Seriously, stop it. It seems to me that all y'all been wanting to do is gang up.
Gang.
Bias, be prejudiced, and gang up.
Gang.
4 against 1. Then you sit up there earlier and made a record before the lunch. You sit up there and made a record about all this stuff that happened in Nevada. That's other acts of evidence, ain't it? How was you allowed to put that on record and not even be truthful about everything that you said? But not one time did somebody say, no, we're going to strike that. Not one time. But if it had been me, it would have got struck. Or if it had been me, it would have been a problem. If it had been me, I'd have been held in contempt. Why was the bond not addressed? Why was the statement of particulars not addressed?
Because there's bull crap.
No filings that I seem to file need to be addressed.
Right.
After you sat there and told me that that's what I needed to do, then you want to refer to the waiver of counsel, which
you did.
Again, for the record, you accepted it the way that I gave it to you, which clearly states on there, I do not waive my right to assistance of counsel. And you accepted that. But you still turn around and continue to violate my 6th Amendment right. Violate my 1st Amendment right by telling me what I can and can't say, which I have the right to say whatever I want to say, and to be heard. That's the First Amendment.
Oh.
You sit up here and talking about a fourth option that you came with out of the blue for Illinois versus Allen when there is no fourth option. Then you try to sneak some other case laws in that you just came up with today. I don't know if you came up with that when you was on one of your breaks that you take. But that it's awful funny that it never got mentioned before. You repeatedly made a false record. You want to sit up here and perpetuate all this disruptive behavior and this, that, and the third, when you knew
that you were stupid
from the point of the start of this trial.
That you're dumb. Yes.
One, that I wasn't prepared. Two, that I did not understand the proceedings.
Oh.
But yet still, you choose to find a way to get around it. Just like you found a way to get around answering what your name was, which you're a public servant, the name that you have on file, with the Secretary of Treasury and State, however you want to put it.
Oh.
You were asked for a certified copy of your oath of office, which you stated on the record you would not provide. Didn't give any case law why you don't have to provide that. Have yet to prove subject matter jurisdiction for the record. Have yet to show that you even have a license to practice law. Haven't proven that yet. And neither has the prosecution. Where's the licenses? Why can't I place your oath of office into the record? Why can't I make that part of evidence? The oath that you haven't even honored, not one bit. Doing enough to keep your face clean doesn't constitute being fair. Doesn't being impartial. When the jury was selected, I struck the whole jury. That never got addressed in any way, shape, or form. When you were informed way before that I was striking the whole jury. So how can you go over that constitutional right, which I have the right?
Shut up! Mr. Brooks, I'm muting you. And the reason I'm muting him is because he has not addressed a single issue that was raised at the end of this hearing today. He is simply rehashing previous determinations of this court. I would describe it as a rant. He continues to impugn the integrity of this court and this process. Again, he did not address any of the issues that I raised at the end of this hearing. From my perspective, the issues that he is raising are all related to claims that a sovereign would make, someone who claims to be a sovereign citizen, claims that have no base, that are baseless in law and in fact.
He's talking mad shit now.
I'm not going to address them any further. Again, they are simply baseless. And with that, I'm going to end for the day. I'll see the parties at 8:30 a.m. on Monday. Thank you, everyone. We are in recess.
Anyway, like I said, y'all need to check out Mushmouth Joe. Check him out. I don't know why his ears hang low. I mean, I think he's a displaced elf. I'm not sure. But yeah, I'm gonna have Mushmouth Joe in my description so y'all can check him out. You know, that's a good question, Jordan. You know, him doing all that slow blinking, that does tend to lend me to believe that there's a touch of Downs in there. But anyway, I want to thank all of you guys for coming by tonight. I want to thank the generous super chats. I do appreciate it very much. And I should be back at some point in time again to laugh at some more of Mr. Brooks. I mean, it's just so much to make fun of and laugh at. You know, no one gets tired of it. So anyway, you guys have a good evening. And just for the record, drums, please.
Drums, please.
Oh, pause. If y'all haven't smashed that like button, please do so on your way out. I appreciate it. And please share, like, share, and subscribe. Okay, bye.
Drums, please.
truly enjoyed ourselves. And we would like to thank you for being a part of the show and coming to visit this platform. Live on YouTube, Auntie Miracle B. Make sure you come back. Because it's all the way live each and every time. Auntie Miracle B.